Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning. Before you begin, thank you all for being here. The court is thrilled to celebrate its 300th anniversary, which is actually May 22nd, but the celebration is today, tomorrow, and Friday. Here in these wonderfully historic buildings from our nation's birthplace, we thank the marshals and officials that run the complex here with Independence Hall, this historic courtroom, where nobody sits any longer, and for allowing us to be here, hearkening back to the fact that we're 70 years older than the U.S. Supreme Court, and our members and those great thinkers were very much involved with the writing of the Declaration of Independence, the writing of the Constitution, and the subsequent development of the judiciary. So again, we thank everybody with the federal government that allowed it. We obviously thank all of our wonderful staff that worked endlessly to make this possible. We will thank them again as the celebration proceeds tomorrow and Friday at the National Constitution Center. I recognize Mr. Bob Mongalucci, Mr. John Hare, Ms. Teresa Fickens-Sachs, Chip Becker, all of whom were instrumental in the planning, and so many of the others that are here.
And our own Justice Sally Mundy.
And our own Justice Sally Mundy, absolutely. Thank you, Justice Todd. With that, we will settle into business. This is not a ceremonial session, but rather a session of the court to hear and decide cases. The first case we have before us, if I have the correct book open, I do, is Commonwealth versus Humphrey. This appeal presents the issue of whether Section 7403E of the Mental Health Procedures Act affords a trial court the discretion to dismiss criminal charges filed against the defendant who is incompetent to stand trial and is unlikely to regain competency in the foreseeable future on the grounds that such prosecution would be unjust due to the passage of time. The trial court answered the inquiry in the affirmative, dismissed 2 counts of aggravated assault by a prisoner. The Superior Court reversed, holding that the trial court may not dismiss the criminal charges until an incompetent defendant regains competency, and the resumption of the prosecution would be unjust due to the passage of time. If that's a fair approximation of why we're here, Mr. Crowley, please feel free to proceed.
A fair approximation with one notation of the charges at issue were aggravated harassment. He's alleged 5 years ago to have thrown urine on a CO at, I believe, SCI Benner, and when transferred to SCI Rockview across the road there, spit on another CO about a month or 2 later.
Thank you.
So it's not aggravated assault. It's not a felony 1 or 2 offense. It's a felony 3 offense with a statutory maximum of 7 years, which of
course is not related to the issue before us in any event.
Right.
Please go ahead and proceed.
Basically, that is a fair assessment. There was after we filed a notice of insanity and asked for a competency evaluation. Commonwealth, at the time our report was presented to the court, we were all in agreement that the man was incompetent to proceed. He had a lengthy history of bipolar disorder with psychotic delusions, persecution complex, delusions of grandeur, and had been a problematic individual for the DOC to cope with. The recommendation of the psychologist was accepted that he needed to be restored to competency. We initially thought that that could be done within the Department of Corrections, but it could not. There was a hearing a year later, which that came to light. The alternative was to transfer him to Torrance State Hospital for the DHS to use their resources to restore him to competency, but it came out that Torrance would not accept him until he either made parole or maxed out of the sentence. At that time, parole, his minimum date was about a little over 2 years away. His minimum date was, ironically, last week, and he still is residing in the state correctional system. I believe he's been transferred to Phoenix from SCI Green. The court, after hearing this, believing that his incompetency was so profound that it's very unlikely he'd even remember facts from 5 or more years earlier, if restored to competency at some point, used 7403 to make a determination that it would be unjust to try him. On appeal, the panel of the Superior Court did not challenge the lower court's findings that competency was not likely restored within the near future and that it would be unjust for the defendant to try him. Instead, relied on this 1988 decision in McGargle, which reads 7403B in the conjunctive resumption of proceedings or dismissal is the title of the subsection. They're reading it in the conjunctive to say that restoration of competency and resuming the proceeding is a condition precedent to actually the court's authority to dismiss it. There are several problems with that analysis. It's basically described in the briefs by amicus and our brief, that to interpret in that fashion really violates rules of construction. That it can unambiguously be, that particular subsection can unambiguously describe two alternatives the court has. Can either resume prosecution if there's a finding of competence, or can dismiss.
Counsel.
Yes.
Question. My understanding is that the only evaluation was the initial evaluation deeming the client incompetent, correct?
That's the only one that was asked for, and that's the only one there was.
And based upon the strict construction of the statute, where do you find it within the statute that there should not be a subsequent evaluation nor a appearance of the defendant before the judge to find an appropriate evaluator?
Somebody has to ask for it. Nobody's asked for it.
So,
until the judge decides.
Is it therefore to be considered a defense technique to seek or to have someone deemed incompetent? Or are you saying it's not a burden? Or let me ask you this. Whose burden is it then to continue the evaluation or seek an additional evaluation or some jail-based competency restoration in order to deem the client whether redeemable or not redeemable? Who do
Anybody
you believe
can
has
ask
that
for it.
burden?
I'm not sure the legislature put a particular burden to continue to.
Well, there is that. That's my concern. The law has no burden. It
Well, that's the
requests.
legislature.
So why, my understanding is that 7403B permits the stay of the prosecution. It permits a motion to have the individual released from jail pending a restoration of competency.
Right.
You're arguing that the court has this inherent right to dismiss the case based upon this inherent authority, despite the fact that the statute indicates he must regain his competency. The question I have for you is, why did you not seek dismissal under 7403D, which specifically discusses the discharge should, as it say, determine whether there's substantial probability that he will not attain capacity. So I guess the question is, in a longabout way, why didn't you pursue it? I find your avenue for remedy to be an incorrect selection of the 7403 statute. Tell me why you, I guess the question is, why did you go with E as opposed to D, which is really asking for a dismissal for long-term incapacity?
I guess we didn't read McGargle or think that it was applicable.
But
and
the
that
statute specifically, I'm kind of confused. It reads, whenever a person who has been charged with a crime has been determined to be incompetent to proceed, as has your client, he shall not for that reason alone be detained pre-trial, nor shall he in any event be detained on a criminal charge longer than the reasonable period of time necessary to determine whether there's a substantial probability that he will attain that capacity in the foreseeable future.
Well,
at that time, it shall be discharged. So I guess,
I take your point, Your Honor. I think the reason we didn't do that was because he's serving another sentence and wasn't going to be discharged anyway.
Yeah,
But our reading of 7403E is that.
but you don't have the authority nor the standing to challenge the prior conviction. This statute is applicable to your case. The statute you claim is applicable. I'm having a hard time finding how that is, and I'm asking you, explain to me why E should trump D.
Well, because that particular subsection gives the authority to the court to dismiss it if he deems it unjust.
Right.
We didn't read the statute as requiring resumption of competency to be a condition.
So it's your position that the particular felony charges for which your client was being detained should have resulted in his complete discharge from incarceration for the prior conviction?
No.
That's what I thought.
Wait.
May I ask a question?
Sure, but I still haven't gotten an answer as to why.
Sorry. Yes.
No, go ahead and answer Justice Doherty's
Finish
question.
your answer to me.
The subsection we filed under specifically gives the authority of the court to dismiss if he believes prosecution would be unjust. So that's why we asked for that relief.
D relates to criminal detention, not dismissal of the charges.
Right.
Justice Todd has a question for you.
Yeah.
As I understand your position and the trial court's order, the trial court believed that, or he found as a matter of fact, that your client would not regain competency, and if your client did at some point in the future regain competency, it would be at such a time in the future that your client would suffer prejudice by the passage of time, and therefore dismissal was in order.
Right.
And your position is that the Superior Court and we should not second-guess that factual determination by the trial court. Is that correct?
I don't believe you can do that under judicial review.
And that's your argument?
Those were his findings. They weren't challenged by the panel below. The findings weren't challenged.
Right, and that's your
just whether or
argument.
not there's statutory authority to discharge him prior to the restoration of competency.
Counsel, can I go back to your opening remarks, and I think Justice Doherty's question. Subsection C appears to require a re-examination every 90 days, at least, once there's a finding of incompetency and a report to the trial judge. Did that not happen here?
Nobody asked for that. We didn't ask for that. The Commonwealth didn't ask for that
It
until.
doesn't, it shall. It's not a question of asking for it. Subsection C provides, following such determination, the person alleged shall be re-examined not less than every 90 days by a psychiatrist appointed by the court, and a report of the examination shall be provided to the court, period. It's not a upon motion. It shall be examined every 90 days.
Which in the real world doesn't happen.
Yeah, except for the fact that if that didn't happen, that's maybe part of the reason we're here.
What, are you asking the court to go to the expense of bringing Dr. Skill?
I'm not asking them to do anything. I'm reading what the legislature has said shall happen. I mean,
It's not the first unfunded mandate in the history of the legislature.
It's not the first time this court said that shall was not discretionary, I think, with the 5-day rule in the DUI cases.
No, I wouldn't go there.
Oh, I'm sorry.
May I ask you, and this is somewhat in furtherance of what Justice Dougherty and then Justice Brobson talked about. I had the same thought. It seems to me, and tell me if I'm right or wrong, that this case is not about detention or incarceration because your client is incarcerated on other charges for goodness knows how long. This case is about whether charges should remain pending against him.
Right.
Is that fair?
That's fair.
And therefore, that's, I think, why, not that it's my job to help you, why you filed under E rather than D.
Right.
D is about getting out of jail. E is about getting charges dropped.
Right.
Does it help your case at all, or how important is it to you that the title of E has the disjunctive or in there?
That's what I try.
The
I was
resumption of proceedings
inarticulately
or-
trying to make that. That's my statutory construction argument. I don't think we briefed it.
It says
Right.
resumption of proceedings or dismissal, then it has two sentences. One's presumption of proceedings, the second is dismissal.
Right.
And that's the way you see it.
That's my bottom line.
Does the rule of lenity do you any good? Because we're not under the criminal code.
The way I look at it, first you say, this is the unambiguous, because it's in the disjunctive or dismiss. The clear meaning of that statute is the judge can either entertain a motion to find that he's competent and resume the case, or he can dismiss it if he thinks justice requires that. That's the first reason to say McGargle was wrong. Second reason is if there is ambiguity in the statute, rule of lenity requires you to interpret it against the state in favor of the defendant. So to accept the premise.
Does it matter for that argument? That's what I was trying to ask you. And I don't know the answer to this. We're going to have to go do a little research, more than we could do pre-argument. Does it matter for that argument, rule of lenity, which is one of the guideposts in criminal law, that this is brought under the Mental Health Act rather than the criminal code?
I do not see how that would matter, because the Mental Health Procedures Act deals with the loss of liberty of a mental health patient.
But again, we're not, and I don't want to fight with you, we're not talking about loss of liberty. That's what the point we just made,
Yeah, but
which I think matters.
yeah.
Let me ask you finally then, apropos of the whole discussion we've had, why does it make any difference to your client, again, in real-world terms, whether these charges remain pending or dismissed? He's confined on other charges. He apparently is pretty incompetent. And in due course, these charges will go away in any event.
An excellent question, and my experience in state pro work leads me to the belief that having a detainer on you does impede your ability to do things in a prison setting.
Fair answer.
I'm sorry, has the ability to what?
Because you have a detainer on you, DOC views you in a different manner. You're denied privileges that other inmates are not given. So a detainer can harm an individual serving a sentence. So having this open case in Center County can adversely impact how he's treated at SCI Phoenix, where he currently resides.
Mr. Crawley, I want to get back to the statute, because I understood this case is about the Superior Court applying precedent that says the second sentence of paragraph E doesn't come into play unless there's a return to competency. That's how I read the issue before us, is whether that statutory construction is correct. Let's assume the two sentences can be read in the disjunctive. And the sentence that you're requiring, that you're relying on, and the trial court relied on, says, if the court is of the opinion that by reason of the passage of time and its effect upon the criminal proceedings, it would be unjust to resume the prosecution, the court may dismiss the charge and order the person discharged.
Right.
Now, what's interesting to me about that paragraph is it doesn't mention anything about probability of returning to competency, which the legislature clearly knows how to say because they said it in D. What it really does to me say is you have to have a passage of time that impacts the ability for the defendant to get a fair trial, to get a dismissal under that language. If I understand the record correctly, this case was dismissed 9 months after the incompetency determination was made by the court.
Right.
Okay. How is 9 months a sufficient passage of time that would trigger a trial court's authority under this language, such that the trial court could determine after 9 months that by reason of that passage it would be unjust to resume the prosecution?
I think Judge Marshall was relying on the fact that there had been no efforts at all to restore him to competency in that period, and no efforts could be started until at least 2 years out, and maybe 13 years out.
There was only 9 months, and the trial court was kind of looking in the future and prognosticating into the future. It may very well be 2 years down the road, he's received no treatment, and at that point in time, witnesses have died, evidence is stale, all that other stuff. But I'm having a hard time engrafting into the second sentence of E the probability to return to attain capacity in the foreseeable future language that is in D, which I think is necessary to get where you want to go.
Other than the panel below didn't challenge that as an abuse of the court's discretion to make that conclusion. I don't think on review we can do that. Judge Marshall heard the evidence. He saw the defendant. He knows the facts of the case. He made that decision that no one is really quibbling with.
Well, counsel, I think to further address Justice Brobson's concern, there wasn't a designation of the amount of time that needed to pass, and that, in my mind, would put it squarely within the trial court's discretion to decide, and unless he abused that discretion, you know, it was a discretionary decision that was within his bailiwick to make.
Although
Now, you agree with that,
would
right?
agree with that.
That was a softball.
And I might well agree with Justice Todd, but a fair reading of what the trial court did here is he threw up his hands out of absolute frustration with a catch-22.
Yeah.
Under our system, you can't get mental health assistance or competency restoration assistance so long as you're a state inmate, and you can't avoid the state inmate status so long as you remain incompetent. And I think the fact that after various orders and various efforts, the trial court could make no headway in getting your client competency restoration services. Well, at least he may sneak by on abuse of discretion, but I think that's what was pushing him. Would you agree or disagree with that?
I agree with that.
Yeah.
Counsel, is your client receiving any mental health treatment?
He's receiving behavioral health treatment. I believe that was testimony at the hearing on the motion to dismiss. There was testimony from the DOC that he sees a psychiatrist every 30 days. I'm sure he's medicated to deal with the manifestations of his mental illness that cause problems in the jail setting, but clearly he's not receiving anything that would restore him to competency. Addressing the symptoms doesn't restore one to competency.
My only question is whether was he receiving any mental health treatment? I mean,
Yes.
based on this record,
That's
one would wonder what kind of mental health services are available to incarcerated individuals. And you know, to get back to my earlier point about the requirement of an examination, I mean, if we're going to say, well, the reality is it doesn't happen, well, then maybe the reality is that the passage of time can't be the determinative factor also.
403F does deal with passage of time, and that caps the amount of time you can hold the stay.
It does,
Is 7 years.
but subsection C deals with the requirement of an examination of individuals who are in need of mental health treatment,
Right.
which isn't happening.
And F deals with the length of the stay. It doesn't mention dismissal. Presumably, if the stay goes on too long, you go back to E.
Well,
And the stay is, let's say the stay is lifted after 7 years.
if the stay is lifted, if the stay has to be lifted at 7,
Right. That doesn't mean the case is
and
dismissed.
he's not competent,
Then I think
what do you do?
you go to E. You go to the second sentence of E and get a court dismissal because of the passage of time, and it would be unjust to try that person.
So if the court could lift the stay while he's incompetent and can be tried, you're saying that the charges wouldn't be dismissed at that point?
No,
If
because the
after
statute-
5 years,
The statute only says that that paragraph
Stay shall be
talks about lifting the stay. It doesn't talk
Right.
about dismissing charges. Dismissing charges is in E.
but practically speaking, if he can't be tried and the stay is lifted, you can't proceed.
Well, I am sort of agreeing with
Have
you.
to be dismissed.
I'm not sure I agree with the Superior Court's reading that there must be a restoration of competency before the second sentence of E is triggered. What I'm saying is E is the only language that addresses dismissal. Everything else is about stays or discharge from custody. And it seems to me if the stay is lifted after a prolonged period of time, you have every right as a defense counsel to go into the trial court and say, too much time has passed. Even if we could get the person restored to competency, too much time has passed, witnesses' recollections are frayed, documents have been destroyed, whatever you want to argue, and it'd be unjust to go to trial at this point. And you ask for dismissal.
But we should have waited till 7 years.
I think you should have, I don't know. I mean, I haven't made my final thought on this, but I'm just trying to say,
Point taken.
as I read the statutory language, it's about passage of time. It's not about restoration of competency.
Justice Bundy has a question, and then we're going to hear from the other side.
Certainly.
Mr. Crowley, what would your recommendation be to this court with regard to the disposition of this appeal? Would you look, is it necessary to have a remand, to have another evaluation of your client?
I think you can say McGargle was wrongly decided.
Sorry?
McGargle was wrongly decided and overturn it. That this remedy does lie in 403.
Okay, assuming that's part of your disposition, what I'm looking for is, at this point, there's been considerable period of time that's passed since your client apparently has
2
been
more years.
tested for his competency. Is that necessary at this point, or is enough time gone by so that your argument is that it's prejudicial at this time for him to face prosecution?
True, it was 9 months between the filing of the termination of incompetency, but it was a year and a half to the incident, and he was not competent at that time because he was suffering from this bipolar disorder with psychotic features. So it's been almost 5 years to date since the first charge was filed in this case.
So, counsel, if we were to take your argument to its logical extreme, if we were to reverse this case, anyone who alleges or is diagnosed with bipolar disorder without and is deemed incompetent would be summarily discharged because they're irredeemably not able to be restored. Is that the argument that you're making?
The argument is, and everybody agrees he was incompetent. I mean, that was not an issue until the motion to dismiss. When they asked for another competency evaluation, the judge said no.
But the question becomes,
But-
was he able to be restored through I guess the question is, if you have bipolar and you are required or you become regimented on taking your medication, you become a productive citizen and competent.
And
The question here
Not
is,
everybody does.
what's the blockage of the client receiving his appropriate medication to have him restored to that level of competence?
it wasn't medication that was in the recommendation that we all agreed to. It was programming to restore to competency, which is more than just giving a Haldol shot or whatever.
And it wasn't just bipolar with this individual.
Psychotic features, delusions of grandeur, persecution complex, those are the reasons inmates in solitary confinement spit on people.
I understand.
Must be a fun client to deal with.
Counsel, can I just see if I might just one short question? Is dismissal the same as discharge?
Interesting question. There's probably a distinction in there.
The General Assembly may use
Discharge.
usage. May dismiss the charge and order the person discharged, which
Right.
suggests they're two different things.
Right.
And he cannot be discharged. If the charges are dismissed here, but he's not discharged, can the charges be reinstated if he attains competency?
It's probably past the statute of limitations to refile it.
Okay, thank you.
Thank you very much.
I don't. That's a good question.
Thank you. Ms. Chapin?
Thank you. Appreciate it.
Thank you, Honorable Justices of the Supreme Court. May it please the Court, Amanda Chaplin on behalf of the Commonwealth. I am asking you to affirm the decision of the Superior Court below, which reversed the dismissal of the charges against the appellant by the trial court. The Commonwealth maintains that the trial court's dismissal of the charges pursuant to Section 7403E of the Mental Health Procedures Act was contrary to both statutory authority and Pennsylvania case law. The evidence was insufficient to support the trial court's assumption and conclusion that the appellant would be prejudiced if he were restored to competency and made to stand trial at a later date. And the trial court should have ordered a competency evaluation by the Department of Human Services rather than dismissing the charges. First, it was contrary to statutory authority and Pennsylvania case law. The trial court erred when it individually and selectively relied on the second sentence of Section 7403E for grounds for dismissal of the charges, rather than reading the section as a whole. The statute's plain language provides the best evidence of the legislature's intent, and the plain language in this case indicates that 7403E is assuming that a person has been restored to competency and then can resume.
Could I ask you, counsel, and I have a little trouble hearing you, maybe like those judges 200 years ago, I need one of those like horns that comes out here. But if the dismissal of charges is not available to an incompetent defendant under these circumstances in E, you're saying, are you not, that the statute here doesn't provide for dismissal of the charges in any circumstance, aren't you?
So there would be two scenarios that are written into Section 7403 as a whole, where the case would have to be dismissed. One would be in E, where someone was restored to competency.
No, but we're putting that aside. Everybody agrees this person is not competent and not regaining competence.
Yes, so if you look at Section F, 7403F, that talks about the length of the stay. And when you look at this case, it's a felony of the third degree, so that is 7 years. So the case is stayed to preserve his rights, but the Commonwealth constitutionally would not be able to prosecute him if the stay had to be lifted. By the Constitution, I can't prosecute someone who is incompetent.
So you're
It's not a
using his
dismissal.
max of 7 years, right? You're using his maximum sentence as the period of time during which it can be prosecuted, brought back to competency?
That is what it would appear to be if you look at 7403F, because it says that you shall not stay it longer than the period of the maximum sentence that they may receive, or 10 years, whichever is shorter. So 7 years would be shorter than 10 years in this case.
Commonwealth.
Yes.
The issue before this court is unique in the sense that the intent of this statute is that if an individual accused of a crime is deemed incompetent, that she is to receive jail-based restorative competency services. In this particular scenario, this is not a singular offense that's blocking the restoration. It's the prior conviction, such that the prior conviction in the current penal state institutions do not permit a state incarcerated individual to get the necessary restoration at either Norristown or Torrance. So what are we to do? What is that judge to do when the system, not within the reading of the statute or any interpretation of the statute, is blocking an individual that the Commonwealth and the defense have conceded would be incompetent? Would the most humane thing not to be withdraw these charges, which emanate from the very psychiatric disorder that he suffers? He threw urine at a guard and spat upon one, which is clearly indicative of his deteriorating mental health. So how was the trial judge to handle this scenario that was not within the statute and not within his or her control? What's your recommendation?
So that's why I brought in the witnesses that I did at the hearing for the motion to dismiss. We have to work within the confines of what we are able to. So what Ms. Pinshires testified to, who works for the Department of Human Services, and what Dr. Wright testified to, who works for the Department of Corrections, they work together in situations such as these. The Department of Corrections will provide mental health treatment for the individual, and the Department of Human Services will send an evaluator in to review that individual, speak with them, and see if they are able to regain competency at that point. And what Dr. Wright did testify to is that the DOC, they can adjust an inmate's treatment that they're receiving within the facility. They can adjust that should they be found to be incompetent. And she also testified that part of their mental health treatment within the DOC is meant to stabilize an individual. So it goes to show...
Matt, stop you. You're getting into a fact-based argument, which is not this court's bailiwick. What we're interested in is the statutory construction of 704, whatever it is, E. So if you could direct yourself to that. Let me see if I can help you along there. Do you concede the statute's ambiguous?
No, I don't think 7403 is ambiguous.
Well, I don't know how you can say that. We're all up here scratching our heads as to whether these are A, the first sentence, second sentence, which is the way your opposing counsel would read it, or whether it's one continuum. And of course, there's an or in its title. How can you say that it's clear? I guess you can stick to your guns, but I'm not sure they're loaded.
When you read a statute, you are supposed to give effect to all of its pieces, and you are supposed to read them together. So there are only 2 sentences in this one section, and both sentences specifically contemplate resumption of proceedings. They both use the word resume. Even the second sentence is talking about resuming. It is stayed under the Mental Health Procedures Act. The case is stayed, so clearly it's contemplating being resumed. The way that it is resumed is if that person regains competency.
But if reading this provision, the 2 sentences of this provision, if the competence is regained, the proceeding shall be resumed. Then if the court is of the opinion by the reason of passage of time, et cetera, it would be unjust to resume, the court may dismiss. So why would it be unjust other than the fact that he has not regained his competence? If he regained his competence, presumably it's not unjust and he can go forward.
So this is where the way the 7403 as a whole is constructed allows for the defendant to assert that there has been some prejudice, which you would have to put on evidence about how the passage of time has impacted your ability to present a defense, whether it be impact on your memory, whether it be spoliation of evidence, loss of witnesses.
Isn't that a strained reading? Isn't it more logical to read this and realize the legislature was saying, look, if everybody agrees, this guy's not, coming back into the realm of sanity, the court may dismiss. It doesn't say the court must dismiss, the court may, and this court in its discretion weighed the evidence and did dismiss it. Isn't that the more logical reading of what the legislature did here?
Well, had the legislature wanted the trial court to have the ability to have the discretion to unilaterally dismiss a case, it would have said that.
It does.
Well, the other argument is it did say that, yeah.
It does say that. I mean, which brings me back, and I hate to keep harping on this point, but this entire statute is based on an understanding that every 90 days a trial judge is going to be told how this guy is doing.
Yes.
And so it would be absurd, let's assume for the sake of argument that the statute works in the manner in which the legislature intended, that every 90 days for 2 years a trial judge gets a report that says he is never going to be competent. He is never going to be competent. He is never going to be competent. The judge certainly can sua sponte say, I'm dismissing the charges. I mean, we're sort of isolating this statute to these 2 sentences without, in my view, looking at the entirety of what is supposed to happen here. So in that, these 90-day assessments did not take place. Why didn't the Commonwealth ask for an assessment? Or do you agree he is never going to regain competency?
I don't agree that he's never going to regain competency. There was never evidence presented to say that. Dr. Scatilla's report didn't say that.
Then why didn't you ask for a re-examination?
I did ask for a re-examination.
All right. And that was denied before, you asked for a re-examination at the same time that the motion to dismiss was filed. Is that accurate?
Yes, I did.
Okay.
Let me ask you, before we conclude, really quick, not only respectfully do I think it's an ambiguous statute, that doesn't mean you don't prevail. I also think there's no case law supporting you. In Hazor, the Superior Court determined that the defendant was competent. Therefore, it didn't have to go to 704E and decide whether charges should be dismissed or not if the defendant remains incompetent. Nevertheless, it did that, but that was pure dicta. Then in McArdle, which was decided some months later, apparently, the court said we're constrained by Hazor to rule this way. And again, respectfully, McArdle was wrong because it was not, the Superior Court was not obligated to follow the pure dicta of Hazor. Now, do you take issue with that analysis?
Well, McGargle decided that 7403E does not apply because they read that section as the defendant having to regain competence first. And they themselves found that there was no case law or statute that allowed for dismissal where the defendant is incompetent.
Did you, in reading McArdle, and I'm sure you've read it, did it not rely on Hazor?
It did discuss Hazor, yes.
And you agree Hazor was pure dicta?
It was dicta, yes.
And let me ask you, because courts generally don't do useless acts. And in the McArdle opinion, the Superior Court said that while we concede the pointlessness of reversing the trial court and reinstating charges for which the defendant will most likely never stand trial, we are constrained to do so, citing Hazor, absent any statutory authority for dismissal. How do you, what's your thoughts about a court being constrained to do what it concedes is a pointless act?
Well, that would go to the prerogative of the legislature and the way that they drafted the statute. Section B puts a stay, but you are allowed to file certain motions where your client is not required. Section C gives you the right to counsel throughout and request, it says that you shall do those evaluations. Then you have Section D, which addresses discharge from detention should there be a problem with not being able to be restored into competency.
And I'm sorry, let me interrupt you. Interestingly, in D, you have the language about restoration to competency. And one wonders whether the General Assembly, if they really wanted to give the trial court authority to dismiss when there's a lack of probability of restoration for competency, they would have put the dismissal language in D in addition to the discharge language that they put in E.
Yes, they had the ability to specify that you could dismiss under those circumstances, but they did not.
All right, thank you very much. Do you have anything you want to add? I think we understand the case.
No, Your Honors, I will stand on my brief for any other remaining issues.
Thank you.
Thank you.
Both counsel. Good morning. We granted allowance of appeal in this matter to examine the manner in which the Superior Court applied the U.S. Supreme Court's case of Bruton versus United States, which held that the admission of non-testifying co-defendant's confession that implicated the defendant at a joint trial violated that defendant's constitutional right to confront witnesses, even though the trial court did issue a cautionary instruction that the statement should only be used against the co-defendant. Because the Philadelphia District Attorney's Office agreed that there was a Bruton violation, precluding us for advocacy on both sides of the Bruton question, we took the very unusual step of permitting a amicus to argue on behalf of the Commonwealth, and then we allowed amicus for the defendant solely as an exercise of parity, so we weren't favoring one over the other. I say that because I'd like to caution all of you that I'm going to be politely insistent that you don't gang up, that you don't repeat arguments that have already been made, and that you only add something that has not been made, because we don't want to end our careers on this case. With that, Mr. Chisholm.
May it please the court. Good morning, Your Honors. I'll be arguing on behalf of the appellant basically what you just stated, Your Honor, that the trial court and the Superior Court erred in allowing a non-testifying co-defendant's confession to be introduced by the prosecutor, where the confession explicitly and unambiguously implicated the appellant as a participant in a robbery and a shooting, and blatantly linked the appellant as a participant in a shooting, all in violation of appellant's Sixth Amendment right to confrontation pursuant to Bruton v. United States and Pennsylvania Article 1, Section 9, Constitution right to confrontation. The Amicus Defender Association will be presenting an argument that the redaction of a non-testifying co-defendant statement with a neutral pronoun is not always sufficient under the Sixth Amendment, and courts must apply the broader approach as required by the United States Supreme Court. With that, I think that there is a concession within the Commonwealth's brief that there was a Bruton issue, a Bruton violation in this case. What we had was facial incrimination, facial implication, and also blatant linkage. Basically, it goes to the sequence of events in this case. You had a witness, Michael Houston, who was the owner of Jack's Firehouse, who employed both Michael Jones, the appellant, and the confessor, Saeed Wilson. Mr. Houston testified that he knew both gentlemen as friends and co-employees. And then, right after that, there was a purposeful placement by the DA's office to have the detective, assigned detective in this case, testify that the confessor's statement basically facially implicated or blatantly linked Michael Jones to the confession by having the detective read in the confession that Michael Jones, my friend at Jack's Firehouse, was the shooter. So with that, we think that we've found a brutal violation with all three of the federal precedents in this case.
And your argument is it was obviously a brutal violation because there was no other person in this trial who could have been identified as my friend, and particularly no one who could have been identified as my friend from the firehouse, because this was his friend who worked with him at the firehouse.
Yes, Your Honor.
Okay.
Again, we had the Commonwealth's brief is from the district attorney's office is conceding the Bruton issue. The amicus is basically relying on Travers. Travers basically says that Travers decries contextual implication and linkage. However, there's clear language in Travers that if there is a blatant incrimination, that is a foul of Travers. So this case even, it presents the blatant linkage, the facial incrimination implication that's even decried by Travers. So, all of the case law seems to fall in complete line that there was a Bruton violation. Now, both the Philadelphia District Attorney's Office and the amicus, the other side of the amicus, are arguing harmless error. And with harmless error, that's a burden that the Commonwealth has to carry beyond a reasonable doubt, that the infirm or objectionable evidence didn't cause the error that we're here today for, right? In this case, if you subtract the confession, all you have is the complainant, Mr. Destin's testimony, his statement, his evidence regarding what happened that night. And I'd ask you to accept that.
Mr. Chisholm, that's not so. You have Mr. Houston, who owned Jack's Restaurant, who ID'd your client as the person in the SEPTA picture that committed the act.
The DNA doesn't tell us what happened inside of the cab. And
so you would say, I'm sorry, I interrupted you, but yes, he was in that cab, he was with the other co-defendant, there was a crime, but we don't know if he committed it.
And what happens is when we look at the absence of any corroborating evidence as to what the cab driver said, then we have the cab driver saying he was shot at close range. He was also impeached, effectively impeached at trial, when he testified that he hadn't taken any drugs, had no opiates in his system. However, his medical records come back and say that he had tested positive for opiates. So now we have a credibility issue, and we also have a perception issue. If a person's high on opiates, their perception as regard to the events that occurred inside of that cab are impacted, and memory is impacted.
There's no evidence that the victim shot himself, so we know one of these two co-defendants or both shot him.
There was a shot in the right upper extremity from the back of the vehicle, which is Mr. Wilson. The two wounds on the complainant's head are lacerations. There's no medical evidence that there's any soot, any stippling, which would be consistent with the close-range shooting inside of a cab in that front passenger compartment. There's no GSR obtained within gunshot residue in that front passenger compartment of the car anywhere, not just on Mr. Destin, but gunshot residue. There's a trace evidence that can be collected from a dashboard, steering wheel. So those injuries on Mr. Destin could be consistent with a blunt impact injury, an airbag deploying, a head hitting a steering wheel, and especially when you consider his credibility issues, that he said he wasn't high on opiates, yet he tests positive at the hospital. That goes to credibility, and it also goes to memory and perception.
Counsel, did the Superior Court get to the harmless error question?
I'm sorry, sir.
Did the Superior Court get to the harmless error question?
They didn't touch that. The harmless issue wasn't presented until my best recollection was the appellant and amicus brief that's before you today. I don't recall addressing any harmless issues.
So should we? Let's assume we find a brutal violation here. Should we get to harmless error, or should we remand it for a harmless error analysis?
I don't think you should get to harmless error.
Well, if we find a brutal violation, doesn't the Commonwealth have an opportunity to? Shouldn't they have an opportunity to argue and, as you say, present a harmless error argument?
I mean, they can present it, but I would ask you to not entertain it, and I'd ask you that certainly remanding it back might be an option. So that would be my response to that. Like the Superior Court didn't address it at all. It wasn't presented in any briefs. Hopefully I addressed that issue.
You did. I think you're saying that if we find a brutal violation, you believe it should be, if we're going to say that they should have an opportunity to argue harmless error, we should remand it to the Superior Court and we should not address that issue.
That's correct.
What's the benefit in that circumstance of having the Superior Court in such a scenario look at that rather than us?
Well,
given that we have briefing.
It would certainly allow me opportunity, I guess both parties opportunity to fully delve into that issue more so as a central part of the case as opposed to more of a peripheral addressing of it. I think this case at the Superior Court was strictly brutal. And when you graciously accepted my appeal, it was strictly brutal. So I think if you were to remand it to the Superior Court, it would allow everybody involved to now focus all of their efforts, employ all resources to make sure we get it right. That on the issue of harmless.
We could accomplish that by allowing further briefing in this case as well before this court.
Yes, Your Honor.
Counsel.
Yes, sir.
Is the remedy you seek that in any time a brutal statement is to be introduced, that there should be a severance of a joint trial? Or no. What is it? What is it that you're seeking?
No, I am not going to present that. I think Bruton made that clear. I'm certainly in line with all of the federal, the trilogy of cases. I think severance in all cases where there's a confession would be an extreme remedy. It certainly would tax from a policy standpoint, it would tax the justice system extremely, having to do multiple trials. I think that what this court should do is to give us a standard that is within the trilogy of cases that's submitted by the Supreme Court. The bright line test that is enunciated in Travers seems to be somewhat unworkable. And on the other, so the other side of the analysis would be when you have an unworkable standard, it's just as inefficient as the situation where you have to sever all of the cases and do 2 and 3 trials and that sort of thing. So since Travers is creating so much judicial inefficiency, I think that the correct way to address that policy issue is for this court to come up with the correct solution on how these type of cases should be handled.
Well, counsel, what is that correct solution? I mean, in this case, was it actually possible to redact this confession in a way that would not have implicated your client? I mean, it may be there are certain cases where you need separate trials. I'm asking you, though, in this case, was there a way for this confession to be redacted in a way that would have neutralized it?
I would not think so, Your Honor. I'm in love with Richardson. I'm in love with the way that Richardson took the defendant out of the statement at all.
Short of that, the other guy is more neutral than my friend, in this case where my friend has already been characterized as the friend from the firehouse. Wouldn't the other guy be more neutral?
Well, the other guy might be, but in the context of this case where the DA's office purposefully placed Mr. Houston's testimony, the other guy at Jack's Firehouse, I think, would still run afoul of Bruton.
Well, we wouldn't say the other guy at Jack's Firehouse, right? We have many cases where they use that term, the other guy. That seems pretty harmless, pretty neutral.
Apropos of Justice Todd, it seemed to me that the case law here, Bruton, Richardson, I think, Travers, our case, is plenty clear, and your argument is there was a misapplication because anybody listening to this statement would know that your client was the co-defendant here. So it didn't seem to me that we needed to enunciate a new standard, clarify Bruton for the U.S. Supreme Court. We just needed to apply it.
That's true. Even under the standard of Travers, this is a Bruton violation. So
are you looking for new law, or are you looking for what you see as the application of clear law to the facts of your case?
I'm looking to have my client back in the Court of Common Pleas. I think that the Defenders Association certainly has a more broader goal, and my narrow purpose here is to convince this court that
you know where you're going, and you're not worried about the road that gets you there.
I couldn't have said it better.
I have one quick question as a follow-up to your answer to Justice Todd's question, where she was talking about the standard used in Travers, where the word substituted was the other guy. And in this case, the word substituted was my friend. And it seems to me that in this particular circumstance, given the fact that the statement itself talked about two different people being my friend, doesn't that weaken your argument in this case?
Well, if we didn't have the purposeful placement of Mr. Houston's testimony, I think I would agree with you. But within the statement, there is a sentence, in my recollection, I won't have those notes in front of me, where there's a specific reference to my friend at Jack's Firehouse. So without the Jack's Firehouse, I think that what you just articulated and enunciated would be correct.
Well, and counsel, as I recall the record, that was also coupled with the boss at Mike's Firehouse saying these two guys were friends at Mike's Firehouse.
That's correct. It would be Jack's Firehouse.
Yeah, sorry. Only one firehouse, Jack's.
Now, you confused me a bit. You indicated that you believe the case law shares with us the way we should interpret Bruton. Richardson versus Marsh, the United States Supreme Court indicated that you can introduce a statement with the hope that the co-defendant's statement would implicate the defendant through other evidence at trial. That's what Richardson stands for. Right. Yet you are challenging the Commonwealth strategic decision to introduce that other evidence which will implicate your client. How is that inconsistent with what Bruton and Richardson are standing for?
Well, I think one significant distinction is that in Richardson, the contextual linkage came after the confession was introduced into evidence. In this case, the contextual linkage was before the statement was introduced into evidence. So when the jury heard the statement, there was no doubt who was being referred to in that statement because they had already heard who the friend was at Jack's Firehouse. Whereas in Richardson, the statement was heard first, and then the female co-defendant made the contextual implication when she testified at court. So all of the three federal cases, Bruton, Richardson, and Gray, say that when that statement is presented before a jury, if there is no doubt, and if it's clear who that person is in that statement, that that's a clear-cut Bruton, and even Travers says that. So that, I think that's the distinction. We have the contextual, the purposeful placement of Mr. Houston before the confession was read into evidence before the jury. So they knew exactly who he was when that confession was read, Your Honor.
But it would be okay if the employer testified after the statement was read. Is that what you're telling us? That line clears the issue, the Bruton issue?
I mean, I would think that that's closer to Richardson than, I mean, Richardson's saying contextual linkage, so maybe it would be compliant under those circumstances, absent the employer at Jack's Firehouse.
So are you sharing with us, you think it's our duty and responsibility to dictate how the strategic maneuver of the Commonwealth should be? Of its introduction of evidence?
No, not at all. I'm saying that to the extent that the Commonwealth's actions in this trial, consistent with the judge's rulings, violated the Constitution, then it would be your obligation to rectify that and to make sure that my client didn't suffer constitutional.
Mr. Chapin, I think you got yourself into some trouble there. Isn't it your position, and I think the U.S. Supreme Court's position, that if on the reading of the totality of the record, it's obvious to everybody in the room who the other guy is, that that's a Bruton violation?
Yes.
And I think maybe where you were going in response to Justice Mundy's question, if I'm not misreading what you were saying, is if the reference to the friends at Jack's Firehouse by the boss had been later in the trial, it might have been less impactful than it was in this case, where it was right before the my friend reference from the confession. But it could have still been impactful, but this was particularly impactful because it was right before the confession was read.
Right, and I was relying on a Third Circuit case, United States v. Richards, where there was a robbery where you had the statement that indicated that there was a friend who committed the robbery, and then right after that you had a detective present the statement, and the Third Circuit said that it's very similar to this case, that, you know, that's where I got my language, purposeful placement. There was purposeful placement of these witnesses, and that purposeful placement created either the facial implication or the blatant linkage.
Okay, thank you.
I think we understand your position.
I did have a question, Chief, if that's
Justice
okay.
Brobson?
We spent a lot of time on the Jack's Firehouse references. Any Bruton concerns with my friend in the front, my friend in the back, he, she, the pronouns that were used there? Any concerns about those, or should we just be focusing on the Jack's Firehouse?
Well, I would think in this case...
Well, consider we had two co-defendants, one was male, one was female, that kind of a thing.
Right, and the facts made clear that it was the female that got into the rear with the confessor, that was a male that got into the front. For my narrow purposes, I might not have any difficulty with your enunciation. I think that's what's troublesome is when we have the Jack's Firehouse, my friend who works at Jack's Firehouse, that was tantamount to saying Michael Jones. And within the narrow context of my client without any overriding policy, legal decisions within the narrow scope of my case, my friend at Jack's Firehouse from Mr. Houston, and then immediately following, that's brutal. And just one final point. There was also in Washington the Department of Corrections. It was almost the same thing. We had Taylor. Taylor was an eyewitness to, he was a participant and an eyewitness in a robbery. We had the confessor Waddy. Waddy's statement was redacted to say the driver and the other guy. Taylor testified right before Waddy's confession was read. I think it was like a 3-day separation. It sounds like it might have been a weekend, but the opinion makes clear that there was only like a few hours from one person testifying to another, even though it was over a course of a few days. That's this case, and that's from the Third Circuit. We have Taylor, who was the eyewitness, and also the Third Circuit found that it wasn't harmless. So it's the same way that Taylor is an eyewitness, and Taylor was high on drugs too. So the same way you have Taylor as an eyewitness, you have the confessor Waddy. In this case, Taylor is Mr. Destin. The confessor is Saeed Wilson. And you have the drug issue that impacted perception, which the Third Circuit said, you know what, that's not a harmless error. So Washington versus, and there were two Washingtons. It went up to the Supreme Court and then came back. But both of them are clear that there was a brutal violation and that the error was not harmless. And that case, Washington, is as close to the instant case as United States v. Richards is.
Thank you very much.
Thank you.
Justice
And I won't,
Gordon's
because
going to finish us.
I don't want to lose the opportunity to get your perspective on this. Was it problematic that the detective, before reading the confession, stated that it was a deleted version of the confession?
Of course. I mean, I couldn't. I think he used. I think the word was redacted in the notes of testimony.
Redacted. Yes,
but
correct.
Certainly, that alerted the jury that there had been changes made, and especially when you read that in the context of the purposeful placement of the witnesses, there was no doubt when that confession was read, that redacted confession was read, and the jury knew they were hearing a redacted confession. And when they hear friend and friend and friend and friend, there was no doubt the person that they were looking at defense table was Michael Jones.
Okay,
Thank you very much.
Thank you.
Mr. Marcus. And you're arguing amicus are you from the Philadelphia Defenders Association?
Yes, Your Honor.
Go right ahead.
Aaron, good morning, Your Honors, Mr. Chief Justice, and may it please the Court. Aaron Marcus from the Defender Association on behalf of Amicus Defender Association here in support of appellant Michael Jones. Instead of providing a preformed narrative, I'd like to just respond to some of Your Honor's questions, I think, as that might be the most helpful. First, I would like to suggest that Travers does need to be clarified to prevent the continuing problem that purely using a neutral pronoun is apparently always sufficient to satisfy a brutal violation. That is not the law, and it cannot be the law.
Well, it's contextual, isn't it?
It is not contextual in the context of the Richardson ban of the contextual implication, but obviousness, as this Court already suggested during the argument, is always going to be contextual in some degree, certainly contextual to the statement itself. And that's something I wanted to get into the second point, which is the statement in this case.
Before you move on, assuming that your position prevails, is it your view that it was Travers that caused the Superior Court to err here?
I think it was Travers and its progeny, Your Honor. There have been several statements either by this Court in simply reaffirming Travers and significantly by the Superior Court in discussing that mere use of a neutral pronoun will always be sufficient. Certainly, redaction of a defendant's name is necessary, But it is not always sufficient to simply redact that name and replace it with a neutral pronoun, as very clearly this statement, in this case, the 4 pages of transcript that this statement occupies. In addition to some of the things that were already mentioned, I mean, this statement within it literally has a point of finger discussion where the declarant Wilson is talking about identifying the person in the back with the purse and the person in the gray jacket in a photograph shown to him by a detective. The accusatory language is beyond the pale. It is certainly accusatory and incriminating.
Mr. Marcus, is there any, under the facts of this case, any way that a statement would not violate Bruton?
Absolutely.
Okay.
Yes.
So tell us how that would have happened so there could be a joint trial.
Certainly. So I actually undertook this process because I believe that was an important question as to whether this statement could be redacted in a way that satisfies the Sixth Amendment and Mr. Jones' confrontation rights. Let me give you actually an example to start out first as to how this could be done in a way that I think Gray even talks about how Richardson exemplifies as a value. So first, what we have is the very beginning of the statement. Starts out, that was read to the jury in the redacted form. Myself and my friend had clocked out of work at about 10 to 11 p.m. on February 5th. We work at Jack's Firehouse. Very simply, just to start, consistent with how the statement's redacted in Richardson and exists throughout this country on a daily basis. It could have been very easily changed to say, I had clocked out of work at 10 to 11 p.m. on February 5th. I work at Jack's Firehouse. Just those 2 lines. It's important to recognize, one, it is clearly still incriminating to the declarant, Wilson, who the information could be presented against, and 2, more importantly, it doesn't have a problem with this contextual linkage because here, the Commonwealth could still introduce Mr. Houston's testimony that Mr. Jones works at Jack's Firehouse, but it's not apparent from the face of this statement at all that Mr. Wilson is accusing anyone. He's not pointing the finger.
Counsel,
that's not what we're asking the jury to do.
Counsel, share with me, where is there any other area of the law that judicial manipulation is permitted for the introduction of evidence when it's influencing the ultimate outcome of the case?
Certainly. And I think one, it's a misnomer to say this is judicial manipulation. The government, the Commonwealth here, is the one who's going to seek to redact the statement, and then the defense has the right to object to whether that statement is going, in the redacted form, is going to violate the Confrontation Clause. The court is going to evaluate it, but I certainly think the government has the burden to say, we want to use this statement, and is it going to be a Sixth Amendment violation? So we are going to redact it in a way that we think is appropriate to allow this to avoid a Sixth Amendment burden. Now, Mr. Wilson, in this case, could have objected, and in some instances, severance may be appropriate. But in most instances, it won't, which we know because the obviousness test, which this court has already talked about here, and I won't hammer unless there are questions on it, has been used throughout this country in many states and many federal circuits for decades without causing significant burdens on either the government or the court in assuring that there are Sixth Amendment protections available, and has not required significant severance either.
Let me challenge that. I understand it. The question that I have is does that not fly in the face of what Richardson stands for, in the sense that the defendant's statement can implicate, I should say co-defendant's statement can implicate your client should there be other evidence introduced? The underlying precept being that we know that statement is speaking about more than one individual involved in a criminal episode. Your remedy is to contort Richardson such that it only appears to be a singular confession performed only by the individual giving the statement to the detective, which to me is such a manipulation, if not a perversion of the evidence. How can we justify that?
So I am not asking this court that in every instance, and there are other examples where we or someone can be used in a variety of contexts. It may not always be appropriate to remove or excise the existence of another person, as Richardson suggested, Justice Dougherty. In some instances, it may, depending on the nature of the case and what the statement is and what it says. It's going to be circumstances specific. In many instances, for instance, let me give you an example out of this statement, right, where I can try to find it, but here we go. So it was the Broad Street line. I'm not sure what station. This could be redacted to say, when me and my friend got off, to instead say, when I got off the subway at Tasker Moore Station, a group of us began to walk together. Someone flagged down a cab as we got to the subway. Right? You can use words that create groups, that create individual participation with more than one. These are certainly valuable and appropriate redactions. Now, this was just my suggestion. The Commonwealth may have a different take on what
But
to
also, Mr. Wilson, who was the confessor, may well object to you attempting to manipulate the statement to take blame from your client, which places it on him. When he gave his statement, he said your client fired all 3 shots, the 2 that grazed the head and one that hit the shoulder. I think as the Commonwealth put their case in, the shot that hit the shoulder came from Mr. Wilson in the back seat, which he didn't want to concede when he made his confession. So again, I think Justice Dougherty's point is well taken. We don't do our trial courts any service if we give them the direction to substantially alter statements to sanitize for Bruton, perhaps distorting the meaning vis-a-vis the 2 defendants.
Stronger argument for severance.
And I'm not suggesting
I
that
think that's right.
I'm not suggesting that you should instruct the trial courts to sanitize statements. The issue is that, and what I'm suggesting is that they may be redacted in a way that I think is constitutionally permissible. That's what I'm suggesting, and I think it's always going to be a back and forth between the person whose Sixth Amendment right is implicated, the defendant whose statement is being introduced, and the Commonwealth. And they're going to have to come up with some statement that is at least reasonably satisfactory to the court and those parties.
I guess we understand your point. It's either that or we sever it. Justice Dougherty?
Counsel, isn't part of the problem here, and you just used the word 3 times statement, the co-defendant's statement.
I meant confession, Your Honor.
But isn't that the point, really? Because this was a statement by Wilson that was intended to inculpate someone else.
That's correct.
This was not really as much a confession by him to anything. It was a statement to inculpate Jones. And that's why this so clearly butts up against Sixth Amendment rights.
I think that's absolutely right.
So there may be some confessions that are really statements that maybe can't be used.
Yeah, certainly the degree of accusation of another co-defendant is going to be significant, and certainly significant for the Sixth Amendment purposes. Where a statement of an individual or a confession of one co-defendant is trying to exculpate themselves and points the finger through accusation at another individual, if that other individual becomes obviously the co-defendant, that is going to be a very clear Bruton violation. That violates Richardson, Gray, and Bruton.
But isn't that an obvious severance issue?
In many instances, it will. It really depends, again, circumstance specific. And if the Commonwealth in this case wants to use this accusation to exculpate, which exculpates Wilson and then implicates Mr. Jones, I do think in order to avoid severance, the redaction will have to be significant. And I do think that's the important point, because it depends always on the nature and circumstances of the case, the statement as a whole, what is being accused by the confessor. Are they pointing the finger at somebody else? That goes back to the very basic concept of Bruton. Why do we have the rule? Right? We have the rule because what we are doing is we don't believe we can ask a jury when a person's statement, a person's confession is entered into the record and it points the finger at another person, to ask the jury to, one, credit the statement against the confessor, but then fundamentally ignore the reliability or credibility of that statement when it accuses somebody else. And Bruton said we can't trust the legal fiction that juries are able to do both, especially when the statement is powerfully incriminating, as the words of Bruton and repeated in Richardson and Gray have said.
We understand. Thank you very much for the insight.
Thank you, Your Honors.
Mr. Baldwin. Good morning.
Morning. May it please the court, my name is Sean Baldwin, representing the Commonwealth as Aplt. I'm excited to argue before this court for the first time, and particularly in this special location. At the risk of not saying the same thing the last two folks said, I will say that I'm breaking my argument down into 2 points. First, that I do believe that Travers, to the extent it creates a bright line rule, it should be overruled. And second, I would argue that there was, in fact, harmless error in this case beyond a reasonable doubt. You already heard, as I said, extensively from the defense bar about how, in this case, the redaction was inartfully done and it was insufficient to protect defendants' Sixth Amendment rights. And you'll hear from the Commonwealth, we would agree in this case. I'm not saying that redaction is never appropriate, but what I would urge this court to do is to, clarify Travers in making a case-by-case analysis on, allowing the trial court on each statement to make a case-by-case analysis rather than the current trend, which is to say, hey, was there a redaction? Was there a limiting jury instruction? If so, equals no Bruton violation. I think that that's wrong.
We're going to have to clarify Travers, so we'll take care of that. Why don't you tell us why this is a harmless error? Because I thought the argument that it's not was pretty persuasive.
Sure. The reason this is harmless error is because, and I'll give you this court's definition of harmless error in Commonwealth v. Markman, where it said an error will be deemed harmless if the error did not prejudice the defendant, or that the prejudice was de minimis, or the erroneously admitted evidence was merely cumulative of other untainted evidence, which was substantially similar to the erroneously admitted evidence, or the properly admitted evidence and uncontroverted evidence of guilt was so overwhelming and the prejudicial effect was so insignificant by comparison that the error could not contribute to the verdict. And I would say all three apply here. Any error was de minimis because anything inculpatory from this statement toward my defendant was proved with other evidence. You have not only the victim's in-court identification, you have the victim's photographic identification, where he identifies a time-stamped SEPTA photo that shows time and location, which corroborates his story of where and when he picked these folks up. You have the defendant's DNA inside the front passenger door handle, right where the victim said he was, and then you have the medical records that also seem to say the same thing as the victim's statement, in that he had a laceration to his front nose, to his ear.
But do we know those lacerations were caused by a bullet as opposed to hitting his head on the steering wheel?
That's not in medical records, Your Honor. However, I think it's reasonable circumstantial evidence when combined with the direct evidence of the victim's testimony that I think it's relatively persuasive in light of all the evidence.
Counsel, did this court grant aliquotter on the harmless error question or just on the Bruton issue?
Your Honor, they granted aliquotter on the Bruton issue. However, I do think that one is part of the other. I think the Bruton issue, the Bruton test, is kind of a two-part test. First is, did a violation occur? Second is, if it occurred, was the error harmless? And so I would say that you can't really have one with the other. The reason, to your earlier question, why the Superior Court may not have spoken specifically to harmless error is because they already found part one of the test to be a no violation.
I ask you, and again, we get lots of cases ready. Does the record reflect here the number of bullets that were found within the car or adjacent to where the incident occurred?
It does, and the record was, the record didn't find, there were no bullets found. There was definitely some doubt, because of how it happened, but it very well could have been that the window was open and bullets fly out. When you're talking about a passenger seat to the driver's seat, although the victim testified he might have believed that the window was up because it was cold. That's still not certain on the record, but.
And what does it do to harmless error that the victim's blood came back from the hospital showing under the influence?
Well, the thing about that, Your Honor, and it wasn't really brought out very much in the trial transcript, but there's not, that's only something that was brought out directly from the medical records itself. No one testified to the medical records. However, a more thorough look at those medical records will also show that the hospital themselves issued the victim oxycodone, which is an opiate, and they can't tell that from, there's no way to tell that those opioids were in the system from before or not. The victim testified he doesn't even drink. It's not a far leap to say a person that doesn't drink might not also shoot heroin.
Well, there wasn't any indication that, or maybe there was, I didn't see any indication that the degree of opiates rendered him intoxicated.
I don't think that came up on the record either. Well, with the exception of the fact that the medical records were moved into evidence, but it wasn't actually explored during a direct cross. Other than that, I would only argue further that the reason we would take this stance is because we, oddly enough, we want to protect convictions. And one of the problems is that when these cases go up past the state courts on appeal and they go to federal habeas, they get overturned. And oftentimes, for example, in the case of Washington v. Secretary or more recently Johnson v. Secretary in the Third Circuit, the lower courts, the state court ruled on the basis of Travers, and it's written in their opinion that, hey, there was redaction, there was a limiting instruction, no violation, whereas it comes up on the court 15 years later, and the court says, we're sending it back to the trial to either retry or release the defendant. So we need to...
Do we want to keep ignoring what the Third Circuit is saying about Travers and its Superior Court progeny?
I think we don't, Your Honor.
Because it seems this court's been doing a pretty good job of ignoring that Third Circuit authority. Not that we're bound by it, but it seems like we're doing a pretty good job of ignoring it, doesn't it?
I mean, a good job is relative, Your Honor. For my side...
That's a trick question, Mr. Baldwin.
I understood so. But as the Commonwealth, I can tell you we've got cases in our federal habeas unit right now that are probably, cases that might support another argument are actually about to get overturned in federal habeas right now. So when we talk about, the idea of severance being a strain on judicial economy is further strained when you have to wait 10 to 15 years to see if these witnesses are back available again.
Thank you very much.
Thank you. Well
Thank you, Your Honor.
Ms. Jappy, is that pronounced correctly?
Good morning, Your Honors. Adrienne Jappy here from the Montgomery County District Attorney's Office, arguing on behalf of the Pennsylvania District Attorneys Association as amicus. Your Honors, the rules sought to be advanced today by the defendant, his amicus, and the Philadelphia District Attorney's Office that the evidence should be considered as a whole when determining whether or not a brutal violation occurred is such a broad and unworkable interpretation of United States Supreme Court precedent, that being Bruton, Richardson, and Gray, and it's not supported by any precedent that will make virtually all redactions, even the most neutral redactions, inadmissible. And this...
Sorry, counsel, but it's actually the opposite, isn't it? Isn't it your position that we ought to validate these Superior Court cases which interpret Travers to say, basically, as long as you've got the instruction and the neutral pronoun, you're good to go? Isn't that the problem with it that we've boxed ourselves into through our cases?
Respectfully, no, Your Honor. I'm talking about the position now that my opposing counsels are trying to advance, and that is looking at the record as a whole, including all evidence of guilt when determining whether or not there was a brutal violation in the case. And Richardson versus Marsh expressly says in no uncertain terms that contextual implication should be rejected. You look at the face of the statement itself and whether perhaps there's any other innocuous evidence at trial that could link the defendant to the statement, but not any other evidence of guilt. And the position advanced by opposing counsel in this case would essentially mean that we have to always have separate trials for joint defendants when there's a co-defendant, or we run the risk of the Commonwealth never be able to use a statement of a co-defendant.
Counsel, I guess the question, though, is putting aside the substitution of pronouns, you're asking us to sort of ignore every other identifying word that may be in the statement or the confession, whatever it happens to be, that is not a name. For example, my friend sitting next to me that day who had a fedora on and an ascot, and then someone comes in afterwards and said, yeah, I saw that person at the scene of the crime. He was wearing a fedora and an ascot. Are you saying that that's fine?
No, Your Honor, I'm not. I'm saying the language, my friend, is fine because that's clearly a neutral redaction.
We've been talking, though, a lot about my friend who worked with me at Jack's Firehouse. Okay. And I'm struggling with the Jack's Firehouse reference because I'm trying to figure out what relevance or importance was it to the Commonwealth's case for purposes of keeping that identifying piece of information in the statement. And isn't that the problem? Isn't that the problem that
is the potential problem?
Substitute the name with a pronoun, that's fine, but if there's other identifying information in the statement that implicates a co-defendant, isn't that the Bruton problem?
That potentially is a Bruton problem. And so let me get to the more narrow issue in this case. But before I do, I want to say the reason why the PDA became involved in this case is for the more broad interpretation here. The potential far-reaching ramifications this case could have on other cases if, in fact, this court adopts the contextual implication approach sought by my colleagues here, an approach that has been expressly rejected by the United States Supreme Court.
I think you're here because the city of Philadelphia is conceding a Bruton violation.
Well, no, Your Honor, that's not why I'm here. That's the narrow issue, so I will get into that now.
The Attorney's Office is conceding a Bruton violation.
That's why you're arguing.
That's why you're here arguing.
I'm here to argue against the broad expansion of Bruton. I'll tell you right now what my position is on the more narrow issue regarding Bruton in this case. We continue to maintain that our position is if there was an error here, it was a harmless error. And then we continue to maintain that the fundamental question before this court, whether or not we should endorse this broad interpretation of Bruton, is viable. And we continue to maintain that it's not. But on behalf of the PDA, we do not now have a definitive position on whether there was an alleged Bruton error in this case, beyond recognizing the distinction between the redaction with mere my friend, which I would submit in no uncertain terms that was in fact correct, but coupling that with the additional language, who I worked at Jack's Firehouse with or my coworker at Jack's Firehouse, that language is more specific and that's more problematic and that could very well be a Bruton violation.
Well, that would fall right in line with Richardson, correct? Anything sharing with the person's existence. I believe the exact language from Richardson is, we hold that the confrontation clause not violated by the omission of a co-defendant's confession with the no, that's not. Oh, when the confession is redacted to eliminate not only the defendant's name, but any reference to his or her existence. So the question becomes, in this particular case, the references to the place of employment. How would one handle that, or what is your recommendation to this court as to handle that, trying to comply with Bruton, yet understanding the Richardson implication, which seems to be broader? Now, the way I agree with you is that there's a difference with the context of all the evidence submitted with the Bruton. Let's just look at the statement on its face.
Okay.
How is it not violative of 1/6 Amendment or our Article 1.9 if, in fact, we are allowing information that truly pinpoints who that person is and how they exist, a.k.a. Richardson? Do you understand my question?
Yes, Your Honor. The only way you're actually pinpointing who that person is with the coupling of the language, my coworker at Jack's Firehouse. And the way to perhaps get around that, and perhaps this should have been done in this case, is to just take out that language, the person I worked at Jack's Firehouse with, and just keep my friend in there, because that would retain the narrative integrity of the statement. And the United States Supreme Court cases and this court holds, if you have a neutral redaction, as long as you retain, and if you're redacting things, as long as you're retaining the narrative integrity of the statement, then that should pass muster under the Sixth Amendment and under Bruton.
But in our quest to protect the Sixth Amendment, are we not manipulating evidence and its introduction, which misleads the jury, even though it may protect someone's Sixth Amendment right?
Certainly, Your Honor.
How do we balance that?
Sometimes we would be manipulating evidence. For instance, if the defendant kept coming back and saying, no, you need to take out this, you need to take out my friend. Well, no, we wouldn't take out my friend, because number one, there goes our part of our conspiracy argument that he committed a crime with someone else. So you have to look at it on a case-by-case basis, what in fact can be taken out of the statement. In this statement, it's simple to just take, because I think there was just one reference or maybe two references to Jack's Firehouse. If that would have been taken out, that would have been fine, because my friend in and of itself could be innumerable people.
The
in fact,
problem was, Ms. Jaffe, that there was also a reference to them being co-workers and friends at Jack's Firehouse by their boss in separate testimony, which came in right before the statement came in.
Right, Your Honor, I understand that.
And you can't edit his testimony.
And I don't think whether it came in before this, I don't think this purposeful placement really had any bearing. And I know there's some Third Circuit cases and perhaps a Supreme Court case that says even if the confession was the first thing in evidence, then you can tell that it was that person. But I think that's just form over substance, even if that testimony from the boss of Jack's Fireplace would have come in later, to the extent that it would identify the defendant based on the Jack's Firehouse language, because that's not contextual implication, because that's not talking about any other evidence of guilt. And that's the important distinction for contextual implication to apply or to not apply. Contextual implication means evidence of guilt. And the reason why
Go ahead, Your Honor. No,
Okay,
please
the
finish.
reason why the friend language is clearly okay, number one, because it's clearly neutral. It could be one of any number of people. And number two, although we learn the defendant is the friend by the owner of Jack's Firehouse, that doesn't necessarily mean this is the particular friend in issue. There could be many friends. It's not till the end of trial when you learn about all the other evidence of guilt. Then you say, hey, well, I think this defendant is the friend, and that's contextual implication, and that is not allowed by Richardson versus Marsh.
I want to make sure I understand your position, because we're going to be, in our ultimate opinion on this case, we're going to be focused on, of course, this defendant, but we're also going to be focused on the broader question of Bruton. You're saying, if I understand you correctly, that a majority of the District Attorneys Association could not reach a decision on whether or not you agree with the Philadelphia District Attorney's position that there was no Bruton violation here. I'm sorry, that there was a Bruton violation here.
Yes, and I want to clarify why.
Please do. I want to make sure I understand.
If it was just the my friend language, I think the association as a whole, we are clear in no uncertain terms that that is, in fact, a proper redaction. It is a neutral redaction.
Right.
It's even more amorphous than the other guy or something like that. And even perhaps the other guy or the other person, someone could possibly think that that's an artificial redaction. But my friend, people talk in generalities all the time. So that's clearly neutral, and I would submit under the case law of the Supreme Court of the United States this court, that is sufficient. It's only when that my friend is coupled with the co-worker at Jack's Firehouse that it becomes problematic, because seemingly that too specifically identifies the defendant.
Gotcha.
So if this court were to write an opinion and find that there was, in fact, a Bruton violation, I would ask this court to be careful and delineate exactly why there was a violation. And in doing so, affirm that the my friend language was indeed sufficient.
Can you envision no scenario, counsel, in which the kind of inference, not just the fact of an inference, but the kind of an inference that could be drawn in some hypothetical could make that my friend problematic? In other words, can you just, are you articulating for us or advocating for a bright line rule about my friend being sufficiently vanilla in all circumstances?
Your Honor, I'm not doing that. All rules have exceptions, and to the extent my opponents here say Travers advocates a bright line rule, it doesn't. And even the Third Circuit says the Supreme Court in Travers advocates a near bright line rule. But all rules have exceptions, like the general rule that juries are presumed to follow the court's instruction. There's an extremely limited exception, why we're here today, Bruton. So let me try to think of an example, my friend.
It's your only friend.
It's your only
You
friend.
only had one friend.
Witness.
If for some reason a defendant is on trial and somehow everyone is aware that he's a recluse and lives somewhere, somehow it's known that he has a single friend. Now, but
the Unabomber.
something like that. So in that situation, and that's why the rule in Travers isn't a bright line rule. There's always exceptions. But generally, the other person, the other guy, the dude, the friend, that's generally an acceptable phrase or pronoun or word to use.
Before you conclude, I want to bring you back to one of your opening statements and see if I understood what you said.
Sure.
I think you said that in evaluating a Bruton violation from a statement, you objected to looking at all of the evidence that was presented at trial to see whether or not the statement was obviously about the non-testifying co-defendant. Is that right or wrong?
That's, Your Honor, Richardson versus March expressly says that there can be no Bruton violation based on contextual implication, and contextual implication is other evidence of guilt.
But the only reason that you've conceded on multiple occasions here that we were friends at Jack's Firehouse is so prejudicial is that we have other testimony from other people that they both worked at Jack's Firehouse. They were there that night. They left together that night. So isn't that the contextual implication?
No, there's an important distinction there, Your Honor.
Good. Enlighten me.
The important distinction is the owner of Jack's Firehouse testified, gave innocuous testimony that these guys work with me at Jack's Firehouse. And that was not other evidence of guilt. That's just evidence of where these people worked. It's only when there's evidence of guilt that links the defendant to the statement.
So,
and even in Travers, Your Honor.
I apologize, but you didn't enlighten me, and I'm trying. I want to make sure I understand this. Therefore, what is the implication of, I think it was Mr. Houston's testimony, that they both worked for me at Jack's Firehouse?
Well,
do we look at that in considering whether the statement, the statement violates Bruton, or do we not look at that?
Well, I would submit, not that I was the prosecutor in that case, but I would submit that the reason the prosecutor put that evidence on is to establish that they were friends and they were part. Therefore, if you're going to commit a crime with someone as a conspirator, it's likely going to be a friend or someone you know. So that was probably to establish conspiracy. It wasn't, I would hope and think, it wasn't in an attempt to link them to the statement. But the reason why, so my friend in there, you're looking at the statement, but my friend is a neutral pronoun. Or a neutral term, so you need not go any further. And but if you do and find out how he's linked, you find out later on at the end of trial, oh, he's the friend, but you only learn that through other evidence of the defendant's guilt. But the problem with the Jack's Firehouse thing, you learn that that's a specific, I don't want to say it's another moniker for the defendant's name, but it's too specific to qualify as a broad neutral redaction. And it's linked based just on that, which is, I don't want to say it's equivalent to facial incrimination, but it kind of is in regards to Justice Weck's question. It's the kind of inference that the Gray Court talked about, and that's arguably a powerful inference if you're describing him so specifically.
So
I wanted to.
I'm sorry.
Oh, no, I'm sorry. Do you want to go?
Just following up on Chief Justice's question. So it's your position, the fact that the redacted statement incorporated or permitted the Jack's Firehouse information, coupled with the owner testimony prior to that, that falls within the Richardson because it's contextually implicating, or are you still of the position?
No, I don't. That doesn't fall within Richardson because Richardson's contextual implication theory says you're not allowed to use other evidence of guilt. And perhaps if I cite language from Travers, it will make it clear. In Travers, when the court was discussing contextual implication, it stated that the redacted statement, like the one in Richardson, became incriminating only, and I quote, through independent evidence introduced at trial which established the defendant's complicity. So it's only when there's independent evidence introduced at trial that establishes his complicity. If that's what links the defendant, then that's not a Bruton violation, because
This
that's
is
the
just
contextual
factual context, right?
Yes, that's the contextual implication theory. And I guess it's confusing because most of the cases that talk about contextual implication, and before I really delved into this, and I just recently, last week, submitted another Bruton brief to this court in another case, so I looked into it further. But the contextual implication theory in Richardson versus Marsh, seemingly when you first read it, it says, oh, well, you can't look at any other evidence. If they want you to look at the whole record, no, that's wrong. Well, you can look at other evidence. You just can't look at other evidence of guilt. Because if you did, of course there's going to be other evidence of guilt. Because if the Commonwealth has two defendants they're going to trial with, one of them gives a statement, of course there's going to be tons of other evidence of guilt against the other defendant, because we know darn well we can't use the declarant co-defendant's testimony against our defendant. So there's going to be abundant evidence. So to come in here and say, oh, well, this defendant is linked to the statement because there's other evidence there, so by that other evidence you can tell that he's my friend, well, of course you're going to tell that. But that's not what Bruton holds. It's very important to remember here that, and I think what my opposing counsels lose sight of, is that Bruton is a limited exception to the general rule. The general rule is that juries are presumed to follow the court's instructions. And it's only in the rare circumstances where a defendant is directly and powerfully incriminated in a statement, then we can no longer presume that that person, the jury, is following the instruction. And we have to remember, in Bruton, the defendant was actually named. The co-defendant said, me and Bruton, or perhaps he referred to his first name. So that was clearly identifying the defendant. So that was the circumstances in which that case was involved. Here, I get it. There could very well be a Bruton violation with the My Jack's Firehouse language. But the my friend language is completely innocuous. It's neutral language.
By itself.
By itself.
Gotcha.
And it's only when coupled with that other language that it's arguably a violation.
Counsel, for sake of completeness, does your association take a position on the effect of any of the detective prefacing his reading of the confession with the statement that it was a redacted statement?
Well, I think in reading the one statement, I'm not so sure if he said redacted. I think he mentioned the version. Perhaps that would have some effect on the Bruton violation, but that wasn't raised by the defendants in this party. It was only raised in the Commonwealth's brief, so that would be a new argument that the defendant didn't
Counsel,
make.
just
So
for
I
your
don't think-
recollection, page 185
Right.
of the notes of testimony, line 15. Do you have the typed version that was provided to you by me? Answer. Redacted one? Question mark. Question. Yes.
But is that the female co-defendant statement, or is that Wilson's statement? I know one of them said redacted, yes, and the other one said, do you have the whatever version?
It was Mr. Wilson.
Okay. But our position I would submit that would be waived because it wasn't raised in any of the briefing here except in the Commonwealth's brief. So I don't think that you can't raise new theories on appeal. So to the extent the defendants would be raising that now, I wouldn't submit that would be part and parcel of the Bruton claim.
Well, what's your association's position on it? Assuming we don't find waiver. I mean, you have an association who won't take a position one way or another as to whether or not this is a Bruton violation, and if this is an added factor that the testimony by the defendant was this is a redacted statement, does that make a difference?
Your Honor, to be clear, we're not taking a position. It's our position that reasonable minds could disagree, and in fact, reasonable minds do disagree
That's what I'm saying.
in this.
You're not taking a position.
On the Bruton violation, correct.
Your concern is this court issuing a decision that says neutral pronouns are no longer good, or my friend is not good. That's your concern.
Well, that's the narrow issue. Our broader concern is if this court adopts a rule that allows for contextual implication, which the Third Circuit repeatedly does, but is not sanctioned by the United States Supreme Court.
Don't you have, what about, I thought the Philadelphia District Attorney's argument on habeas concerns was an interesting concern. Does the District Attorneys Association not share the concern that if the Third Circuit has adopted contextual implication that these cases are just will go up through here, but they'll go through federal habeas and get reversed anyway?
I don't want to say I don't share the concern because I'm very well aware that we have numerous cases. In fact, I have one that got reversed.
You'd rather fight the battle in the Third Circuit and keep trying to convince them.
Hopefully one of these days, the United States Supreme Court is going to grant cert on one of these cases. But I will say, this court is not beholden to the Third Circuit. This court has consistently, properly interpreted and applied the Bruton Trilogy. The Third Circuit, on the other hand, they basically hold that any neutral phrase in a redaction will result in granting of a writ of habeas corpus unless there's a substantial...
Well, now you've jumped from one rote application to the polar opposite rote application. Doesn't the case law stand for nuance, stand for context, and stand against rote application on one pole or another? In other words, you're arguing in favor of what our superior court's apparently been doing with this rote position that a neutral pronoun plus a cautionary instruction, you're good to go. And now you're saying that there's an opposite rote view from the Third Circuit, is what I'm hearing.
Well, Your Honor, with all due respect, I'm not arguing that in Pennsylvania state cases it's a rote position. The rote position taken by the Third Circuit is inconsistent with United States Supreme Court. What I'm arguing in this case, in the Travers opinion, which discusses neutral pronouns, it's the general rule. It's not a bright line rule. There's always exceptions to the rule. It doesn't specifically say as long as you have a neutral pronoun and a cautionary instruction, that's sufficient. It does not. It says you need to have a neutral pronoun. There can't be any obvious indication of any redaction. The statement must still retain its narrative integrity, and there must be a cautionary instruction. And even this court has found in some situations in which there is a neutral pronoun that doesn't necessarily pass muster under Bruton. And in that regard, I want to direct Your Honor's attention to Commonwealth.
Finish up for us, please.
Okay, if I could just direct Your Honor's attention to, I believe it's Commonwealth versus Markman, Pennsylvania, 2007. That was a case in which the other guy was used. And if this court adopted a bright line rule, well, then you would say that that was sufficient. But in that case, the way in which it was read to the jury, it was an audio recording. And every time the other guy came in, it was a voice dub. So it was clear that there was an goes to my point that we don't rotely, as a prosecutor and an administrator of justice, if I don't 100% believe that something was or was not a violation, I'm not going to come in here before this court, lose my credibility, and argue that.
We appreciate that.
You did a fine job. Thank you very much.
Thank you, Your Honors.
Well argued.
Give us 1 second, Brian. Let me close the door. see how long this would take. I think we should. Let me test it. We should. No doubt. So to those sides. Sally got it?
Commonwealth of Pennsylvania versus K. Brown, representing Mr. Brown and Mr. Carl Morgan, representing Commonwealth of Pennsylvania.
Good morning.
Justice and Justices, Carl Morgan from the Defender Association.
And let me, for the benefit of the public and also to make sure that the court and you and opposing counsel are aware of the issue the limited issue we want to decide. The case involves the propriety of an evidentiary ruling precluding a criminal defendant from presenting expert testimony regarding the blood alcohol content of the Commonwealth's principal witness and the effect on the witness's memory and perception. The lower court concluded that the expert's testimony constituted an inadmissible assessment of the witness's credibility, and you challenged that rule and want to put the expert report and testimony in.
That's correct, Your Honor.
Go right ahead, Mr. Morgan. Thank you.
Well, first of all, let me get to the elephant in the room. What the expert wanted to testify to was extrapolated evidence of blood alcohol content. In this case, I don't want to go deeply into the facts, but it was a state trooper where there was an altercation at a fast food line, a fender bender, and in the course of that, the state trooper who was armed, well, let me step back, he was not in uniform. My client, Mr. Brown, didn't know he was a state trooper, though we keep referencing him in his title as state trooper. Mr. Brown didn't know that, but he knew he was armed. And the state trooper was extremely drunk. And he got into an altercation, and then my client was not being physical or violent or aggressive, but the state trooper then put his gun in his car and came back and said, you know, if you want to fight, let's fight. My client, instead of fighting, instead of doing anything aggressive, went around him, took that gun from the car that it was in, right where the state trooper was, to extricate that gun from that situation, because it was a dangerous situation.
Or the fear reference is to steal the gun.
If you think he wanted to steal the gun, then fine. But when the police finally, he got in the car, there was a car chase. The state trooper, as drunk as he was, started chasing him.
Counsel, the question here is...
Well, can I just answer the Chief Justice's implication? He said when the police came and they finally caught it, stopped everybody, he gave the gun to the police officer, still in the holster.
Mr. Morgan, let me follow up for and then we'll go to Mr. Justice Doherty and Justice Mundy. What struck me immediately is a disconnect between the crime charged and the evidence you wanted to put in. The crime is possession of the firearm.
That's correct.
You could argue the jury or the judge as the trial finder, is the fact finder, can get into the motivations of your client or the like. Who cares how drunk the state police officer is? It seems to me completely irrelevant to the charge against your client, which is that he stole the gun and got caught, picked up with it. So it seems to me, again, completely irrelevant to the case, inadmissible even, the alcohol level of the victim.
Two things, Your Honor. When you say who cares, well, first of all, it goes to the fundamental fairness of my client's, did he get a fair trial? And he didn't get a fair trial because there was not evidence of how intoxicated the police officer was. The Commonwealth says, oh yeah, we let the jury know he was extremely intoxicated at .18.
Mr. Morgan, my question must not be clear to you. Assume on that evening I was drunk. Would it pertain to this trial? Obviously not. What I'm suggesting to you is the alcohol level of the state police officer is completely irrelevant as to whether your client took the gun or not.
Yes, well, it is relevant, Judge, because had the testimony come in from the expert, he would have testified that people of a certain blood alcohol level can be highly aggressive, can have a loss of judgment, a loss of memory, loss of perception, and depending on his testimony about that, the trial judge, may have altered their ruling on whether or not a justification defense should have been given.
But wasn't the gun laying in the back seat?
Yes, but within, the state trooper was right there.
But
I've had many a case where my clients have been charged with possession of a gun and it was in like a car and they were outside of the car. It's constructive possession.
Didn't the state trooper get out of the car and put the gun in the back seat? Am I remembering that incorrectly?
Yes.
So
It
he
was
was out of the
always
car.
out of the car. It was always in the back seat. Then he came to confront my client, but it was always in the back seat. The argument is my client didn't know how drunk this guy was and what he was going to do, whether or not he was going to go back to the car and get the gun and use it. The third party that was out there testified that before the police trooper put the gun in the car, he was, and this is in the record, fidgeting with the gun. Now, query, what does that mean? I don't know, but does that mean that he was contemplating whether I need to use this gun or not, whether I need to keep it on my possession to use against this guy that I'm going to fight with?
Counsel, it's my turn.
No, I want you. 1 second, please.
Okay.
It does not assist your case, nor your client, for you to override the questions being asked. The reason we're asking you questions is that we're going to go back, vote the case, and write the opinion. So when somebody asks a question, I would greatly appreciate it if you would stop, listen, and answer the question. And with that, Justice Dougherty has the floor, and when he's done, Justice Mundy has the floor.
I apologize, Judge. I thought I did answer the question.
Let's proceed.
The issue before this court is whether the introduction or the preclusion of your expert testimony impermissibly stepped on the credibility determination or lied to the jury. I have a question for you. How, in fact, does this statement, which is your introduction to Lawrence Gazzardi, medical doctor's expert testimony, quote unquote, this is far more alcohol than Trooper Lowry admitted at the time of his accident or at the time of the investigation. You then go, the statement then goes on, Trooper Lowry's perception, judgment, memory, and inhibitions would have been markedly affected by his level of intoxication. His recollection of the incident must be considered unreliable and distorted because of the effects of alcohol on his cognitive ability. They cannot be considered reliable, especially in view of the statements about his alcohol consumption. Share with me how that's not a credibility call, not whether they fidgeted or any of the facts. The issue here is, if there's a credibility call, did you usurp that from the jury such that this motion to eliminate should have been granted? So I'm asking you point blank, is your expert's statement, not whether he wanted to do an extrapolation argument, but what was proffered to the court, did that step on the province of the jury as a credibility call as to whether the detective or the state trooper was believable or not?
I concede that evidence should not come in because it's an individualized statement about the state trooper's credibility.
That's the issue that we're here for.
And or reliability. Okay. I thought, and I stressed in my brief, that reliability and credibility was different, and that's the position I took. Therefore, the prohibition about an expert not going toward the credibility of a witness doesn't apply when you're talking about reliability. But if your honors believe that reliability and credibility are the same thing, then I concede that he should not be talking individually about that state trooper. That does not end this appeal, and that does not end the issue here, because then my position is he should be allowed to testify generally about the effects what an individual with a 0.24 blood alcohol content would be, and the different characteristics.
And let's explore that. In DUI, it's almost like a strict liability crime. If you blow higher than a 0.08, you're guilty. Tell me how it's within the realm of science, skill, or experience, which are the three key words for an expert testimony, that someone blowing possibly a 2.4 is not over 0.1088, such that he's guilty. Isn't that a reasonable common understanding?
Well, it's not a common understanding, and I pointed out there's this great case I point out from Illinois, where an expert was called to testify about the effects of alcohol and blackouts. And in terms of blackout, the expert witness said that you could have a blackout, it's like a shotgun approach to the mind, and that one could be waking and functioning in his job and still have memory loss. That at a later date, he'll fill in the blanks of that memory loss. The answer to the question, Judge, if I could finish, so I don't get accused of not answering the question, is that layperson doesn't know that. What a layperson knows about blackouts generally, and I think all
There's
of
no
us...
evidence.
that you
First
go-
of all, counsel, there's no evidence of blackout. The issue before this court is not Illinois, it's Pennsylvania law. And the law is if you're .08, you're guilty. And the question that you just posed is that this would be a general intoxication. General intoxication, if anyone's blood level exceeds .08, the general public knows that that means he's guilty, such that no expert testimony is needed unless you refute that.
I am refuting it. I'm saying that a layperson does not know the intricacies of certain blood alcohol types. The legislature has broken down different degrees of intoxication with .0. They start at .08 as one level, then there's a mid-level, then the third level, the most egregious level, is .16 and higher. Why did they do that? Because there's a difference in those blood alcohols, a difference in culpability, a difference in dangerousness. I'm saying the layperson, a general layperson, doesn't know the distinctions of what a .08 is, a .16 is, or a .24 is. And the expert would have testified as to those differences and what that means. And would have testified that a person with that blood alcohol would have had a greater loss of memory, greater lack of judgment, greater aggressiveness, and I think going back to Justice Baer's question, how is this even relevant? Well, it's relevant in that had all this evidence come in, and the breadth of that evidence we don't know. I cited in footnotes of peer review studies of what the expert would have relied on. So we don't, had the wealth of his knowledge come in, the trial court might have said, you know what? I think a justification defense should be allowed here. Because a person that drunk, who knows if they're going to, Justice Todd, go back to the car and get that gun and do something. And since a justification defense is part of the case, then it's relevant as to that. And it would make a difference in the outcome of the case where if there's justification, then he's not guilty of taking the gun. He's justified in doing that. And I would submit to Your Honors
hang on.
that
I think you've answered the question. Justice Mundy, do you have a...
My question's been resolved.
Well, since I see no questions, take 30 seconds and conclude, please.
And
I think we understand your position.
This is not a theoretical determination of whether or not a justification defense should have been given. Because the jury came back with two questions. They came back with, can self-defense be unlawful? And one of the other questions was, in terms of the theft of the gun, what is the definition of lawful taking? So clearly they were struggling with my clients, whether he was doing lawful action, whether he was justified, and a justification instruction would have helped them.
Is that, counsel, I just want to clarify because I had understood, as I read the briefs, that your expert testimony was really going to go to the credibility of the witness as the witness was on the stand, meaning the credibility of the trooper's testimony at trial. You're now saying that the reason why you wanted the expert testimony was not to respond to the trooper's testimony at trial, but to support an affirmative justification defense.
Yes.
Okay. I didn't have that.
And more so, it wasn't to attack him individually and call him a liar or attack his credibility. It's in order. It's basically giving the.
If I could just interrupt for a second, what Justice Doherty read about memory impairment and things like that, that would seem to go to his testimony at trial and would have nothing to do with his conduct that would cause your client to be in fear of an intoxicated person who had the capacity to realize, oh my gosh, I need to take my gun off and throw it in the car, I'm about to get into a fight, but may then, maybe losing the fight, go back and get the gun. That's the problem I'm having with the expert testimony you wanted to give and how that relates to anything other than what the witness is testifying that day.
Only if that if the expert's testimony is limited to memory and perception, but he also wanted to get into aggressiveness and lack of judgment. And those deal with what's possibly.
You feel confident that you made all those distinctions clear on the record in this case in front of the trial court?
I think that was in the report of the doctor. And again, his was not to individually attack the police officer, but just to give an assessment of credibility, just generalized factors that a person at .24 would be allowed to, that a .24 had. Just general characteristics, and then the jury on their own, not telling them what it was, but they could see whether or not Lowry fit into those general characteristics.
Thank you very much, Mr. Morgan.
Thank you, Your Honor.
Mr. Green?
Good morning, Your Honors. May it please the Court. Andrew Greer, arguing on behalf of the Commonwealth.
I apologize. I misread my own handwriting.
No problem, Your Honor. I want to skip to counsel's claim that this expert was just going to speak about generalizations about any person with certain blood alcohol content. As Justice Doherty pointed out, the expert opinions proffered in the expert's report all went to credibility, reliability, and a potential.
Why was total preclusion appropriate? Why, if that reliability statement was taken out, wouldn't this have been proper evidence on intoxication and relation back? Isn't that kind of evidence accepted around the country regularly?
What I'm saying, Your Honor, is a expert opinion making generalizations wasn't offered in that expert report. When it was precluded by the trial court, defendant didn't say, hold on, what if we just got our expert to say that any person who stopped drinking 4 hours before testing .018 would have had actually had a BAC of 0.24 at the time of the incident here.
Well, I thought the question, and this is, I thought, why the case was interesting from a jurisprudential standpoint, is where it falls on the continuum between Alicia and Walker. Because if it's more like Alicia, then that leans more in your direction. But if it's more like Walker, that would seem to more lean in Brown's direction. So I'm interested in the issue of why scientific evidence about relation back and intoxication is not the kind of thing that aids fact finders in this Commonwealth.
What I'm saying is that the expert opinions offered here didn't specifically go to relation back evidence generally to explain the holding of Walker and how this case is different. Walker just simply held that the trial court, it wasn't a per se bar. It was within the trial court's discretion to allow expert testimony specifically regarding the reliability of eyewitness identifications because there were demonstrated misconceptions about the infallibility.
Just one brief follow-up on that. Could you answer this? What is it about an expert testifying about eyewitness identifications that's more scientific than an expert testifying about blood alcohol content and titration in the human body
what I'm saying
over
is
time?
Yes, the there were demonstrated misconceptions about the infallibility of eyewitness identifications, meaning the average layperson would go, well, they identified that person. You know, I would be able to identify someone who, for example, just came up and robbed me. And what an expert can offer there is saying, well, that is actually demonstrated to be untrue, and it's counterintuitive science, and it is the subject of expert testimony in light of those demonstrated misconceptions. Here, it's common knowledge that a drunk person could be belligerent, could forget what happened, their memory could be unreliable, but the expert opinions, again, that were offered here went specifically to saying that he would have had this particular person would have had to consume far more alcohol than he admitted. In Walker, the expert was only permitted to say witnesses generally their identifications are not infallible. Again, the proffered opinions here went to his perception, judgment, memory, inhibitions, all these things that are common knowledge that can be affected by alcohol. So there weren't any demonstrated misconceptions that the average layperson would go, drunk people are always true.
I didn't mean to interrupt you. Does it alter your thinking at all that he wanted to present a justification defense, that he had to grab that gun because he was worried that this wildly drunk and irrational state trooper would go grab it himself and possibly use it on him, and that his defense was constrained by the inability to put this evidence in?
No, Your Honor, because I will first acknowledge that here the trial court ruled that it would not, that a necessity defense, which again is just one type of justification defense, was not appropriate here. The Superior Court affirmed on that, and that question was not left open in the Alicotter order here. But again, the defense was for necessity, not just simply there's several justification defenses, and it could be, as defendant said, whether he was reasonably in fear of danger. That's not what a necessity defense means. He has to have taken the only option possible, which in this case would be taking the gun from the complainant's car. And an expert who didn't witness that a justification defense is going to be dependent on the specific facts of the case, like what actually happened. The complainant can testify to that. The defendant can testify to that.
But experts, let me interrupt and ask you, experts, this is what experts do. They weren't there. They're not fact witnesses. This expert was proffered, I guess, among other things, to opine on the physiological impacts that alcohol has on a human body and over time. And why does that not provide a window for the jury, if the jury chooses to credit it, on what was going on or what might have been going on at the time? Why doesn't that get over the bar to admissibility?
Again, Your Honor, I don't mean to be evasive here. What I'm saying, I believe the expert's opinions that were proffered here don't go to that. If the expert had rendered opinion saying any person who stopped drinking 4 hours before on a breathalyzer test, they registered a 0.18% BAC, would have had a BAC of 0.24% at the time of the incident. That opinion, that would be admissible. Then based on that, defense counsel in closing could argue that, well, you can't find him credible because he must have lied about how many drinks he had. That would be appropriate to argue based on that limited expert opinion. But what the expert wanted to do here was directly comment on credibility simply by saying, using the methodology of retrograde extrapolation, I have deduced that this specific person would have had to have this many drinks, and that he only admitted to fewer, and that his perceptions and memory can't be trusted. That is inadmissible as commenting directly on a witness's credibility.
Well, wait, so you're saying an expert can never be offered to contradict a fact witness?
No, an expert can and has been done so in cases where
right, so in this case, the police officer says, I had 3 beers. And an expert's not permitted to come in and say, based on my scientific study, my review, my thing, it's impossible. You're saying that's not allowed because it's attacking his credibility, or is it simply offering a contrary factual narrative for the jury to embrace?
It would be, but that was not offered and was not based on what the expert said that he reviewed, which I think doesn't.
I agree with you on that. I have had a hard time grasping the movement of the appellant's theories here, but I'm just trying to understand that an expert can offer contradictory testimony.
Yes, and based off of that, defense counsel could make an argument about how that goes to credibility, but it would have to be limited to certain generalizations, which are not how these expert opinions here were framed as generalizations. So on that basis, Walker's different. On the basis of the subject matter of the expert opinion, which here is alcohol, as opposed to demonstrated misconceptions about eyewitness identifications, this really all just goes to credibility, which is
Doesn't every case ultimately come down to credibility? Isn't the jury eventually going to decide who's telling the truth?
Yeah, and it's the jury's exclusive province to determine that.
And don't experts provide testimony that allows them to make that deduction?
Yes, experts are allowed to make testimony, or are allowed to give testimony from which it can be argued, or from which the jury may infer an opinion of a witness's credibility. In another case where a different opinion was offered, unlike the case here. If your honors have no further questions, we would just ask that you affirm defendant's judgments of sentence.
Thank you, counsel.
Thank you.
We are going to go straight through and decide the final two cases in deference to the National Park Service that wants to clean this room up before they quit today. And where is Ms. Murphy? She's coming.
We will wait.
Is it appropriate to start without her?
No.
Brian, our counsel on the last case here, why don't we switch the orders, argue the last case now, and then we'll argue this case after Ms. Murphy joins us? You what?
Okay, she'll be in from the.
Get us a case, Brian.
Chief, I said.
You argue first?
Yes.
Hold on one second.
Take a breath.
Yeah, take your time.
Okay.
We don't need to rush you, we're sorry.
Again, I apologize.
No,
no
don't be
worries.
silly. And the case has been called. Let me explain what it's about, And actually, in this case, this is a little difficult, so listen and tell me what you think. The Environmental Hearing Board rescinded permits issued by the Department of Environmental Protection to Gibraltar Rock to operate a quarry. The rescission was without prejudice for Gibraltar Rock to reapply seeking a new permit. The Commonwealth Court reversed the Environmental Hearing Board's rescission order and directed that there be a remand to DEP. DEP and multiple interveners who are represented here today appealed to this court, arguing that the Commonwealth Court erred by reversing the Environmental Hearing Board's rescission without prejudice order and directing the matter and arguing that the matter should have been remanded to DEP. Gibraltar and DEP, interestingly, both assert that the Commonwealth Court erred by sua sponte raising and deciding multiple issues that were never properly preserved for review before it. The local entities, who were interveners, did not take any position on preservation, but did argue the merits of those questions. So with that unusual procedural posture, it would be my suggestion that the parties at least argue the rescission without prejudice versus the remand issue. And then, if you want, discuss whether the other issues are preserved for review. Now, any party can argue preservation review and the merits. However, time is limited, and it's entirely proper to rest on your briefs for any of these arguments that you want to. So again, with that somewhat unusual procedural posture, as we find ourselves taking the case from a Commonwealth Court, Ms. Murphy, feel free to go ahead.
Certainly, thank you, Your Honor. Again, I'm Margaret Murphy. I represent the Commonwealth of Pennsylvania Department of Environmental Protection. The appellants are splitting our time. I had planned to address the Commonwealth Court's procedural and substantive errors. I'll sort of put that second, and I will talk about why remand to the DEP would be inappropriate at this point. Counsel for New Hanover, Andrew Belwar, will argue on behalf of the townships and citizens, and he had planned to address, but he may also truncate his arguments, why the focus of the Commonwealth Court on the Hoff VC site is a red herring. The EHB was correct in its analysis of Article 1, Section 27 of the Pennsylvania Constitution, why rescission is a reasonable remedy here, and Gibraltar's failure to address any of the 8 questions that were allowed by this court. So I will turn to the end of my argument, and then I will come back to the discussion I wanted to go through related to why the Commonwealth Court's decision is so problematic for the Department of Environmental Protection and why we're taking the unusual position here of asking this court to reinstate the Environmental Hearing Board decision that rejected DEP's issuance of the permits. We recognize this is an unusual posture. Remand would be unproductive for remand to the department would be unproductive at this point in time because the uncontested facts found by the Environmental Hearing Board are that Gibraltar failed to meet the statutory requirements to qualify for a permit. They failed to make the threshold demonstration that operation of their quarry would not cause pollution.
Counsel, let me jump in here. I think that is an interesting question about whether the quarrying operation would cause pollution to the quarrying site, particularly when pollution was already seeping toward that site, and I think the testimony on which the Environmental Hearing Board relied said it was going to continue and eventually go onto that site. So the question of whether this permittee was going to actually cause pollution that was going to happen anyway, I think is a very interesting question. There was no appeal to the Commonwealth Court from the EHB decision on that regard.
Right.
So we don't really get to that. On the remand versus the rescission without prejudice, isn't our review in the Commonwealth review just a simple abuse of discretion? Whether the EHB abused its discretion in rescinding, I guess it was a rescission in any event. The question is whether it was just a dismissal or a remand. Why on what basis could we possibly conclude that a rescission and not remand was an abuse of discretion by the Environmental Hearing Board?
I don't think you could conclude that rescission was an abuse of discretion by the Environmental Hearing Board. The department agrees that rescission is the appropriate remedy. I don't know if I'm answering your question.
Well, I'm trying to get down to the nub of the issue that I think the Chief Justice wanted you to address, which is if this case boils down to simply a remedy, and the Environmental Hearing Board was empowered to do both, we're reviewing it for an abuse of discretion, which is incredibly deferential, right?
Right.
Okay. So is there, your view of it is there's no possible reason how we, exercising our deferential standard of review, could conclude that the EHB abused its discretion?
Correct. Okay. Yes. And the problem for the department is that we're bound by the Environmental Hearing Board's finding that Gibraltar's operation of the quarry would make the pollution worse. We're bound by those findings.
Well,
we're bound.
Again, I understand that, but I think, again, there's an interesting question as to whether the quarrying operation would have made the pollution worse or would have actually abated it before the Department of Environmental Protection got to doing it. But again, those issues were not appealed.
Those issues were not appealed, and we're bound by, and I think they're findings of fact, I could find them for you, I believe they're findings of fact 2012, 2013, 2014, in which the Environmental Hearing Board, let me find those for you, in which the Environmental Hearing Board specifically concluded sort of that additional point that, yes, it's coming to the quarry, but operation of the quarry, pumping of the groundwater for the operation of the quarry would make that pollution worse and would cause pollution to areas that are not currently polluted. So the Department of Environmental Protection is bound by that. There was no question to Commonwealth Court regarding whether or not those findings of fact were appropriate.
I'm sorry to interrupt you, but you keep saying you're bound by that. But if there was no record evidence supporting that conclusion, are you precluded from taking an appeal to this court, arguing that the Environmental Hearing Board made an error of law or an abuse of discretion by adopting findings of facts that are unsupported? In a general sense.
It's hard to answer that question because I think the evidence is clear. And part of the problem for the department was that during the de novo hearing, evidence was presented to the Environmental Hearing Board that was not available to the Department of Environmental Protection, evidence that was very compelling and persuasive. Further, there was
for
evidence...
that reason, the department actually changed its position.
Right.
Issued a grant and today doesn't contest that the grant should have been vacated.
Right.
And counsel, that's because the department never hired its own expert. They relied on the expert of the quarrying operation.
That's correct.
And that was a finding of the Environmental Hearing Board that was an abrogation of responsibilities under the Environmental Rights Amendment.
That's correct.
Okay.
Well,
And is that because the Department of, the DEP doesn't have the money to hire its own experts?
I can't speak to that question, and I don't think that question was addressed specifically by the Environmental Hearing Board. We have limited resources and funds, and we have to allocate to the priorities in terms of protecting public health and safety. For this particular hazardous cleanup site, we had spent that money to connect impacted residents to a water line. So the resources that the department did have, we put towards abating the immediate threats to public health and safety. I think there was another question.
Hey, Justice Brobson?
My only thing was what was before the department was a permit application. And the department gets permit applications relatively frequently and doesn't hire outside experts for every permit application. You review the permit application, you have internal people that review the content of the application, correct?
That's correct. That's correct. In this case, though...
No, I'm sorry. I think you've done a very fine job on the issue that's principally before us. I don't know if you want to comment at all on issue preservation or merits of all these collateral issues that, at least from my reading, the Commonwealth Court, I think everybody's reading, Commonwealth Court sua sponte raised, and argued and decided.
I think the one issue I would like to raise to the court in my time right now, and otherwise rest on the arguments made in our briefs, is the consequence of the Commonwealth Court's discussion of de facto takings, Article 1, Section 27, and the Non-Coal Act are really problematic. And so we request that the Commonwealth Court decision be reversed and those errors be corrected. We already have litigants who are citing the Gibraltar Commonwealth Court decision in the appeals we're receiving. We have more than 20 appeals pending before just the Environmental Hearing Board, and that doesn't include appeals before the Commonwealth Court and this court related to Article 1, Section 27. And the error of the Commonwealth Court's conclusion, particularly that failure to include Gibraltar, failure to issue a permit to Gibraltar to allow them to undertake a quarry operation so they could help with cleanup, may violate Article 1, Section 27, is extraordinary. It doesn't follow this court's precedent in the PEDF cases or in Robinson Township, and is probably contrary to those cases. There's no factual record that supports this, perhaps offhanded statement by the Commonwealth Court. Nonetheless, it's being cited by litigants, and we need to have that corrected. That's in part why we sought appeal to this court.
So if the court, if this court decides the dismissal versus remand issue and otherwise reverses the Commonwealth Court, does that satisfy DEP's needs?
I think if the reversal is clear in communicating from a precedential perspective that the Commonwealth Court can't be relied on.
Would it be clear in your mind if we vacated that portion of the Commonwealth Court's opinion?
I think so, if the precedential effect is that it doesn't exist and can't be relied on.
We try very hard to be clear in our opinions.
Thank you. No, the argument's helpful.
So I think that I'll rest on my briefs with regard to the other issues and just respectfully request that the Commonwealth, that this honorable court reverse the Commonwealth Court, vacate or reverse or correct the errors in the Commonwealth Court's decision, and reinstate the order of the Environmental Hearing Board. Thank you. Again, I apologize for my tardiness.
No
Thank
need.
You. Thank you.
Mr. Belwar, going to argue next.
Good afternoon. Andrew Belwar on behalf of New Hanover Township, as well as arguing on behalf of the citizens group Ban the Quarry. As I was waiting, as outside, I saw all the children outside visiting. I'm reminded when my mother took me down to see Liberty Bell and Independence Hall, brought back great memories.
What you can't see is that the children are heckling us through those windows.
I did not see. But I appreciate the opportunity to argue in these hallowed halls, and thankful to be part of the celebration of the Pennsylvania Supreme Court celebrating itself as an independent court. It's fitting that you chose this case to be argued here today, in that we're close to where the debate and passage occurred of the Declaration of Independence and the United States Constitution. I reviewed very quickly the preamble to the Constitution. It talks about we the people, in order to form a more perfect union, establish justice, promote general welfare, and secure the blessings of liberty to ourselves and to our posterity. Special words, to be sure, but they don't mean anything unless there's legislation behind them. Of course, the key piece of legislation here is the Non-Coal Mining Act. And the issue for you is remand versus rescission. And I would suggest to you that there is absolutely no basis to consider remand when the applicant for a permit failed to meet the express criteria, express requirements in the Non-Coal Act. That, I suggest to you, is unappealed, it's uncontested, because we look to all the findings made by the trial judge in this case, the board.
I think Justice Brobson asked your opposing counsel, and I don't know if your answer is any different. There's no law on remand versus dismissal without prejudice, so it seems to fall to the EHB's discretion, which, if that's so, it's a very high bar to show abuse of discretion under those circumstances.
I agree wholeheartedly.
Right.
I think.
So I guess that's my point is, we don't have to issue a decision that says Absolutely, there is no opportunity for remand when a permittee fails to when the EHB concludes that the permittee has failed to satisfy their burden. We don't have to do that, do they?
I don't think you have to do that.
Okay.
I think you need to give trial courts the discretion because of the different fact patterns that appear before them.
I mean, we may very well, if they would have remanded, we may very well said I mean, that's not an abuse of discretion, but I'm concerned that you're taking it to another level and saying we must say that the only remedy here was dismissal.
I would suggest to the court that based upon the undisputed facts in this case, the undisputed conclusions of law, you must rescind, you must uphold the rescission in this case. Again, specific to this case, you have very unique facts. You have.
Is it okay if I just said it wasn't an abuse of discretion?
I prefer, yes.
Okay.
I prefer the vacation that was suggested.
That's a different issue. That's the collateral issues. Justice Brobson's referring only to the remand versus dismissal without prejudice. And the smart answer is that's perfect, Justice.
Understood. But again, this is a unique situation. It's some 300 acres that are proposed to be mined next to what is in essence a mini love canal. It is a site that contains some 20 different dangerous chemicals, and they're flowing. And to your point, Justice Brobson, how do we know that mining will cause further pollution? Well, that's a fact established by the board after hearing 5 days of testimony.
Yeah, I think whether something is a cause under a statute is a mixed question of fact and law. And again, this issue wasn't preserved. I'm hearkening back to my 3-week trial in front of the Environmental Hearing Board with K.N.L dealing with a trash transfer permit. So, you know, I think there's a very interesting question as to whether someone who comes in and wants to quarry and may expedite the movement of pollution from one property into that property, but nonetheless is proposing to treat it, something that DEP still has been unable to do, whether that is truly causing pollution that is going to happen anyway.
And in this case, I would suggest that on the record, there will be pollution caused because the contaminants are moving, it's expanding, the plume's expanding. However, the drawdown from the mining, this is going some 300 feet deep, the drawdown of the water is going to pull these chemicals.
I said it's going to exacerbate it and it's going to make it faster, but again, we don't have to have this discussion because nobody appealed the issue.
We don't. I think it's significant, though, because of the township residents, because of the residents who formed Ban the Quarry group. They're the ones who have to live with this, and they're the ones who are going to suffer from these chemicals moving. Some will be treated, perhaps, if they were ever to reach the quarry. Others are going to move and never reach the quarry. It's those that are the pollution that really cause the concern here. But in any event, I suggest no remand is warranted here in any way, shape, or form. There's no legitimate purpose for it. I harken back to the court's decision from 2007 in the Station Square gaming case, where the court noted that in that case, a remand would serve no purpose. So in that case, you reinstituted the rescission. I suggest that it makes sense to do this.
Is the idea that things will drag on too long, is that a factor to be considered in deciding between remand or rescind?
It certainly is to my opposing counsel. To me, it is not. The idea that the Gibraltar is focusing on what may occur in the future is a concern, legitimate concern, because there's no plan for how to handle these. However, the reason you're going to, I suggest you should rescind, uphold the rescission, is because of what happened in the past. Not concerns about the future, but what happened in the past, which is that Gibraltar failed to meet the express requirements under the Non-Coal Act. They failed to meet the express requirements under the regulations under that act. They failed to meet, in conjunction with the department, the requirements under Article 1, Section 27 of the Pennsylvania Constitution, which requires pre-decisional evaluation. Was not done here. And so those are 3 strikes. Gibraltar should be out. The rescission should be upheld.
What about the fact that Gibraltar Rock started this permitting process well over 10 years ago, 2011, and the fact that historically DEP has had knowledge of the contamination of this site since the 70s, and for whatever reasons, financial, lack of resources, haven't remediated this site, so it remains polluted. Doesn't that lend some credence to the fact that perhaps Gibraltar should be allowed to come back to the table? I mean, hey, they could say to you, look, you let us remediate the area, and you let us, mine our quarry. Isn't it have some benefit to you in that aspect?
And Gibraltar could do that today without the permit. I would suggest they can't get the permit because of the express requirements under the Non-Coal Act regulations and the Constitution, but they certainly can. I have another client that's entering into a prospective purchasing agreement with DEP, where we're going to buy the property and we're going to clean it up. But
so
we
the
don't have any.
What you're saying is the disposition on this case doesn't rule out that.
Not at all. Not at all. They could start addressing the issues now. They could purchase the property, start addressing it. They could do it from afar. They could do it in conjunction with DEP. But the permit should not be allowed to stand because it never met the criteria in the first place.
Well, a remand doesn't necessarily mean the permit stands.
It doesn't, but what it does is, I suggest, it sends a wrong message to the board that even if you find, and it's uncontested, that the requirements for issuance of a permit in the first place were never met, we're going to keep that permit alive.
No. A remand doesn't keep the permit alive. They can't take the permit and start quarrying. They're back before the DEP. It doesn't keep the permit alive.
But it keeps alive something that was void ab initio, in the sense that...
It keeps the permit process alive so they don't have to start all over again, something they started 10 years ago.
But they can apply to today, tomorrow, for a permit.
Yeah, but
it's just with this permit, when we went before...
You ever applied for permits in front of DEP before?
You're going to tell me it's
'Cause I have.
a difficult process. I understand.
Starting over can sometimes be difficult.
To your point, though, if you were to remand, if the Commonwealth Court had its way and this remanded, just think through what that would involve. Wouldn't we be back in front of DEP arguing those same issues for which we had a 5-day trial in front of the Environmental Hearing Board? And then whatever.
This is all very interesting to me. I'm not going to. I don't represent Gibraltar, and I'm not going to hypothesize what I would do as their counsel if I went back in front of DEP. But the bottom line is, the HB findings and conclusions of law were not appealed, so they are what they are.
It should be a fairly straightforward case.
Would you like to comment at all on preservation and other merits issues?
The only one that I'll address, if I may, because I'll defer to DEP as regards preservation, is the idea that this court issued an order saying we would like 8 issues addressed. At best, 1 issue was addressed. I would suggest that is under the rules, that is an admission and agreement by the opposition, by Gibraltar, as regards the briefing that we presented to the court. And yet another reason why you should decide in favor of not only the township and the quarry.
Pragmatically, we get 2,000 requests for allowance of appeal a year, and in looking at those and deciding what to grant or not grant, we don't have the same don't put the same resources in that we do at this point and subsequent to this point when we take it. One of us takes a record apart, reads every word, and writes an opinion. So we may have been erroneous in granting on all 8 issues because we weren't aware of preservation, non-preservation. We looked at the Commonwealth Court opinion and a petition for allowance.
Understood. But to my mind, you're taking an awful chance as a party before this court to just not bother to address.
Thank you. No, I think that's fair.
Yeah. All right. In conclusion, I ask that you reverse the decision of the Commonwealth Court, reinstate the rescission order, and allow it to progress that way. Thank you.
Mr. Harris, please proceed.
May it please the court. Steve Harris, attorney for Gibraltar Rock. You talked about how long this case has been going on. I've been representing Gibraltar Rock for 21 long years in an effort to We've got all the zoning approval. And there's a fundamental misunderstanding here that somehow Gibraltar Rock did not meet the requirements of the Non-Coal Act. We initially started this process in 2001 and applied to DEP for a permit in 2003. That permit was issued in 2005. We then, because of the litigation, unending litigation over the land use matters, came to the point where the Environmental Hearing Board said, you really ought to go back and reapply for your hearing. Gibraltar Rock is in total compliance with all of the Non-Coal Act issues, except it has the misfortune of being next to the good oil site. But that is actually an opportunity. Gibraltar Rock is not the problem. Gibraltar Rock is part of the solution. That's why we want to go back on remand. Justice Robson, you're absolutely right when you say this is an issue of abuse of discretion. And it is helpful to read what the Environmental Hearing Board said. It said, however, given the lack of any momentum at that site, we are concerned that a remand pending HSCA, Hazardous Substance Control Act activities, would drag on indefinitely, again giving rise to the staleness concerns that required a remand of our first adjudication. Well, first of all, concerns aren't evidence. Secondly, the issue of whether or not there was a lack of momentum, the record is clear that the representative from the Hazardous Substance Group said, look, we're going to run a pilot study. We've already have the money to run that pilot study. We're going to be doing that. We're not closing down our remediation. So the question, and Ms. Murphy made a very important observation here. She said the reason that this matter was overturned was that the department had not had the opportunity to consider the testimony from Dr. McLean. What happened in this case is very instructive. The township got the Gibraltar Rock's Fate and Transport study, gave it to their own expert. Their own expert had criticisms about it. Did they share that with the department? No. They held that report until the appeal in order to weaponize that report.
Mr. Harris, I think you're a little far afield. The question that was asked of both of your opposing counsel, by Justice Robson initially and then by me, is whether EHB abused its discretion in choosing between dismissal without prejudice or remand. And I think Justice Robson made the point that if EHB had decided in your favor, if you will, for remand, that still would have been within its discretion. So I think the narrow inquiry on this issue is where or how did EHB abuse its discretion?
They abused their discretion because the reason given by the EHB for rescinding rather than remanding, I'll read again, however, given the lack of any momentum on that site, we are concerned that a remand pending HASCA activities would drag on indefinitely, again giving rise to the staleness concerns that required a remand from our first adjudication. There is no evidence in the record to support that. As a matter of fact, the evidence in the record is the opposite.
Well, and I think that's your best argument, and because the argument that you can never satisfy the condition of the permit is in my experience, there's been remands like that before, but your argument is that's not the reason why the board refused to remand. The board didn't say we're not remanding because it would be a futile act, you could never satisfy the criteria. They said we're not remanding it because DEP doesn't have a plan to remediate the site, and it's just going nowhere, and we're just going to stop it now.
Yeah, and the record is clearly the opposite on that particular point. And the reviewer, the two DEP permit reviewers testified, hey, if we had Dr. McLean's report, we would have considered it. And we would have made Gibraltar Rock respond to all the issues raised, and then, and not until they had responded to them, would we have issued the permit. All we're asking is to go back to the department, allow the reviewers to review the report, allow us to respond to it. This is, I suggest, like the EQB products case, where this court said the Commonwealth Court's decision is affirmed to the extent it is consistent with the direction below and is vacated in all other respects. And that's what we're asking for. What we're asking the court to do is to affirm the decision to reverse and remand and vacate the sua sponte issues. That will give us, as Justice Brobson pointed out, to file another permit application is an enormous undertaking in terms of time and money. There's no need to go back to the start again. We can submit, the department will do exactly what it said. It will ask Gibraltar to respond to concern A, B, and C. We'll have the opportunity to do that. And if we are able to do it, a permit will be issued. But I do want to comment, Chief Justice, on the fact of the, and I understand why you criticized that I brought up the issue of this report that the township didn't share with the department to allow it to consider these issues. Had they done that, we wouldn't have had any of this litigation. The permit wouldn't have been issued until those things were concerned. So we would have saved 5 days, and Justice Brobson knows what that's like in front of the Environmental Hearing Board. We would have saved an appeal to the Commonwealth Court.
But counsel, the EHB is essentially a de novo process, and usually the permittee is there to defend the permit. Usually the department lets the permittee do that. It's not uncommon for expert reports to surface during the EHB trial process.
Well, what I'm saying is they had the report before the permit was issued. The department said if we'd had it, we would consider it. All that we're requesting is that you remand this matter to allow the department to review the report, to do what it normally does. If we can't satisfy the department, the permit won't reissue. If we can satisfy it, it will. It's fundamentally unfair to require us to go back to square one. So to summarize, we'd ask you to affirm the finding of the Commonwealth Court that it should be reversed and remanded, but vacate those issues which were raised sua sponte. Thank you very much.
Thank you very much, Mr. Harris.
You made Justice Brobson feel like he was back on Commonwealth Court again, and he will be reminiscing all day. Well, we're happy to have him.
Ms. Marie Charles Azar, representing the Department of Human Services, Ms. Kathleen Kim, representing K.N.L, Ms. Judy Springer.
The case pertains to a former caregiver's, please proceed. Thank you. The case pertains to a former caregiver's motion to intervene in adoption proceedings of a 12-year-old child. The caregiver asserts that he is in loco parentis, or at the time he filed his petition, he was in loco parentis to the child. After a hearing on a motion to intervene, the trial court found the caregiver lacked standing because he failed to demonstrate that he is currently acting in loco parentis. On appeal, the Superior Court affirmed on the basis that the caretaker failed to demonstrate in loco parentis. We granted allowance of appeal to determine whether the lower courts misinterpreted or misapplied Pennsylvania law as it relates to in loco parentis standing in an adoption proceeding. In addition to the merits, I think perhaps I would appreciate your commenting on whether the child at age 12 is refusing consent to adoption, which would just moot the entire case if it was returned to the trial court.
May it please the court, I'll start by introducing myself. Good afternoon, Your Honors. Marie Regine Charles is here for the appellant. Your Honor, in regards to your question about the child's consent, I believe that that is a matter to be determined at the actual adoption hearing for the hearing on the merits, but in regards to standing, that shouldn't be part of the evaluation to determine whether or not appellant has standing to even file.
In other words, first we need to decide standing.
Correct.
Consents and any merits issues, that's not before us today, correct? Thank you.
Is the record unclear on whether when push comes to shove the child will consent or not?
There was never ever any evidence presented one way or another outside of a mention in child advocate's brief that the child is not willing to consent. So that was never even litigated.
I think that's fair enough. So why don't we get to the standing and intervention and in loco parentis?
Okay. May I ask one more clarifying question? Does your client currently have a petition to adopt that's
yes,
pending?
a petition
it is
to
still
adopt
pending.
was also filed.
And it is still pending?
I believe that when trial court dismissed the petition to intervene on the adoption, he also dismissed the petition to adopt.
But that was, he did not voluntarily
He did not
withdraw it.
voluntarily
Okay.
withdraw
Thank you.
the petition.
Thank you.
Proceed, please.
Basically, trial court's argument is that appellant does not have standing because at the current time of the hearing, appellant did not stand in loco parentis. So the issue is the issue here is trial court's use and definition of currently standing in loco parentis. So we can see the fact that DHS was involved in this case, child was removed and DHS took custody of the child. Therefore, to say that appellant did not stand currently in loco parentis is to ask appellant to accomplish a feat that's unaccomplishable. Because once DHS stands in, that bond, that standard of in loco parentis is cut.
It seems to me a very subtle word game. As I understand the law, and correct me if I misunderstand it, at the time a person files to adopt,
correct,
they must be in loco parentis to the child.
Well, actually,
they do not have to be simultaneously for a period of days or weeks or months prior to that. So, for instance, the child's 15, somebody raised the child for 14 and a half months, for 6 months has been indisposed. The 6 months, the fact that they're not living with the child at that point doesn't destroy in loco parentis. On the other hand, closer to this case, you're with the child for 5 years, you're not with the child for 6 years. I think there's a real question if you're in loco parentis. Is that your understanding of in loco parentis?
Well, let me start with,
Go ahead.
You asked about adopting and who has the ability to adopt. It's clear that the Adoptions Act says anybody can file to adopt.
Which brings me to the argument or the question. Why does your client not just file a petition to adopt as opposed to a petition to intervene in a current adoption?
He did. Because at the time...
But he withdrew it, or
No,
it was
he did not
dismissed
withdraw.
by the court.
Yes. Your Honor, at the time, the reason why we started with an intervening motion was because the maternal aunt had already filed an adoption petition. So there was already adoption proceeding somewhat in place. So we were filing to intervene, and then we also filed our own adoption petition in addition.
At the same time?
Within, I want to say, less than a month, we filed an adoption petition.
Filed the petition to intervene first.
December, the petition to intervene was filed. January, the beginning of January, the petition to adopt was filed. And that was all prior to any court proceeding starting.
Which brings us to the interesting issue before this court and the Alicata issue granted is, did the trial court err by misinterpreting and misapplying the law and our appellate court decisions, denying TB standing to intervene despite uncontroverted proof that TB stood in loco parente for the subject child by assuming the role in discharging. The question I have is, where is it in the statute that there is a need or a requirement for in loco parente standing to intervene in an adoption?
The Adoption Act, you mean? There's no requirements in the Adoption Act. However, I think the issue of standing is more court procedure. Who has standing to bring forth a claim, a case, a petition? So procedurally, that's how the trial court was moving forward.
In loco parente is really a term of art created in custody.
Correct.
But you're asking this court to adopt that custodial standard in an adoption arena.
Well, Your Honor, I don't think I'm here today asking the court to adopt any specific thing. My argument is that trial court misapplied the law by denying my client standing to even move forward in the adoption process.
We go back just a moment. Yes. The in loco parentis standard arises, well, it's been in common law for a long, long time, but in Pennsylvania, it is in the custody statute, correct?
Correct.
As a requirement, but it's not in the adoption statute.
No, not at all.
So to file a petition for adoption under Pennsylvania law, any person can adopt.
Correct.
Can file a petition to adopt. So, statutory loco parentis is not required.
Correct.
That standing concept is not required. However, I think you're correct. Courts have traditionally viewed in loco parentis as part of the adoption petition process, or at least part of the petition to intervene process. And I wonder, could you clarify, is it different in a petition for adoption from a petition to intervene in an existing adoption proceeding? And I'm asking with respect to this requirement of loco parentis.
Well, as Your Honors know, sometimes procedure happens and it's followed and it's not necessarily law. Like we stated, the Adoption Act does say anyone can file for an adoption. I think it's just become common law and common procedure to discern whether or not this person has a vested interest to even file, a genuine interest to even file to adopt a child. So therefore, that's when the whole concept of in loco parentis came into mind.
So it kind of migrated from custody cases over to adoption cases?
Correct.
And you're not here today to argue that in loco parentis is not necessary. Rather, you're here to argue that your client is in loco parentis.
That is true.
So if I'm 74 and my wife and we're wonderful parents, and this seems to be an at-risk child, and I think we could take better care of him than anybody else, I can't file a petition to adopt him and get to the merits, can I?
If you're technically
No, I've never met him. I've never met any of them. All my exposure is getting ready for this argument.
So just to clarify, you're saying you're technically a legal stranger, correct?
I'm a legal what?
Legal stranger.
I am a legal stranger.
So you could file, but you would be denied because you have no kind of connection to the child.
But you'd be denied on the merits. You wouldn't be denied from a standing perspective, because under the statute, any person
Correct.
can file.
On the merits.
Wait a minute, I'm not sure where we are there. As I understand your argument,
I think you have to be a local parentis.
it's not that any individual can file, it's any individual may become an adopting parent. So that's that. So what we are talking about here is, I thought, that the error in your assertion is that the trial court failed to convene an adequate hearing on standing, and that your client should have been granted standing. And we're not here to determine the merits of any adoption that may or may not occur once the court hears the merits. It's just that your client under in loco parentis was entitled to a seat at the table and was improperly denied standing. Isn't that correct?
Exactly.
Exactly.
Because your client is in loco parentis.
Because he did stand in local parentis.
Okay, so finally, let's get down to just that issue.
Okay.
How do you deal with the fact that the trial judge found him not to be credible? We all read the trial judge's opinion and understand that for whatever reason he appeared to be somewhat intolerant of your client. But putting that aside, because he's still the trial judge and he makes credibility determinations, he found your client not credible. He found that the facts of the case were that your client had not had a relationship with the child over the last 6 years. Doesn't that preclude in loco parentis standing?
And just to make sure I understand you correctly, Your Honor, yes, he did find that he did make a discretionary determination on credibility. And then you said, I didn't hear you correctly when you said the thing about the
He
last 6
found,
years.
I thought, that your client had not had a relationship with the child over the past 6 years before the hearing.
Okay.
Between ages 5 and 11.
So in regards to credibility, the trial court absolutely has discretion to make a credibility judgment. However, facts are facts. The fact is that the appellant lived in the same home with this child for the first 5 formative years of that child's life. He did day-to-day activities with her. He took her to doctor's appointments. Even the situation that commenced the DHS stepping in, it was a doctor's appointment that appellant took the child to. So he did assume responsibilities as a parent. He did complete parental duties for the child. That's a fact.
But that's contesting the issue on a ground that I thought was not. I thought the issue here is whether there was the issue for us is whether there was a legal error. In other words, the trial judge said it doesn't matter if your client was in loco parentis for that 5 years.
Correct.
Because the law, some inchoate law, requires current in loco parentis status, and that seems to me to be the legal issue before us, is whether that was correct. And I haven't found authority for why current in loco parentis status is required, because I think, as one of my colleagues suggested, that would, or maybe you suggested, that would be a non-starter in this proceeding.
It's impossible.
A foster,
because DHS is involved. It's absolutely impossible for anyone outside of DHS to currently have the in loco parentis status.
But
once
it was a 6-year gap here, right?
There is a 6-year gap, but nowhere in the law does it state anything about there must be a 1-day gap, a 1-week gap, 6-year gap.
The gaps are relevant. The question is, at the moment he filed the petition, was he standing in loco parentis?
Well, Your Honor, at the moment, no, but however, that is not the question, because that's not the law.
Right, but that's what Justice Weck said. The trial court found the exact issue the Chief Justice just articulated. Did he stand in current in loco parentis status despite a 6-year absence? And the question would be, is that the abandonment of this legally recognizable status? And the question that I would have to that is, if we're taking consideration of post-separation in our termination proceedings, 2511A1 gives you an allotment of 6 months. Why should we not consider post-separation contact in whether they should be reunited with the child?
Well, Your Honor, in order to argue that, I'm going to bring into account some facts. So something that wasn't argued or really touched upon is the fact that appellant has always been here. Throughout the dependency proceeding, appellant has always been here. At one point in time, appellant had visits with the child. Appellant sent gifts to the child. Appellant has always tried on his end.
Counsel, let me interrupt you.
Yes.
I don't want you to answer the legal question by changing the facts. I think the question asked is, assume hypothetically that he saw the child for the first 5 years, did not see the child for the next 6 years. So for the first 5 years, he established in loco parentis.
Correct.
Over the next 6 years, he was not in loco parentis. At the time, he took his petition for adoption down to the filing office and handed it in. Does he maintain his in loco parentis from 5 years past, assuming the 6 years?
Well, Your Honor, as you stated to me, the facts are the facts. You can't change the facts. The facts is the fact that he did stand in local parentis.
So-
Regardless of the 6-year gap, at one point in time, he stood in local parentis.
I think we're finally getting there. Is it your position that once you obtain in loco parentis status, you never lose it?
Yes. Okay. I mean, if you can prove that you stood in local parentis and you have a genuine right to file some kind of adoption proceeding, if you have...
Now, that's fair enough. If you're the biological mom of the child, you never lose it.
Correct.
And you want to say the same thing about in loco parentis?
Correct. Because, I mean, as we previously stated, the facts are facts. You can't go back and repaint the past. He stood in local parentis for this child. I do concede that there was a 6-year gap, and but however, there was never an abandonment as other councils would like to
Well, counsel, if
portray.
I could just, and that thing about those facts, about those 6-year facts, those will be merits issues, right?
Correct.
That's the point. We're here on
Yes.
standing. Isn't that right?
We're basically here, my appellant is trying to get through the door. Once he gets through the door, then there's another evaluation that's done on the merits. And a lot of the issues that have been brought up to keep him from even coming through the door are merit issues that should be determined at an actual adoption hearing, whether or not the child consents, whether or not it's in the child's best interest, whether or not there's actually a bond. It doesn't change the facts that he has earned the right to walk through the door.
He wants the ticket to get into the show.
Correct.
Could I just ask, I asked this earlier, and if you answered it, forgive me because I didn't understand your answer if you did. With respect to standing, which is what we're focused on, is there a different standard in terms of standing for filing the petition for adoption and filing the petition to intervene?
Standing is not something that's outlined in the Adoptions Act in regards to who can file. So, appellant had a right to file. He was not precluded from filing.
A petition for adoption?
A petition for adoption.
Okay, and then with respect to the petition to intervene?
And in regards to a petition to intervene, the process that the trial court conducted was whether or not he had standing to intervene.
Right. So
And
I'm
that's
asking
where we're
you,
at
what's
today.
the difference? Is there a difference?
I would say that would be for you guys.
Let me throw you a lifeline.
Correct.
Okay.
Rule of Civil Procedure 2327, who may intervene? Who may intervene? A person who should have been originally joined, or could have been, or a determination that the person has a legally enforceable interest. So the definition of legally enforceable interest has been brought into the adoption arena under the armor of in loco parente.
Correct.
Despite the dearth of law or this court's imprimatur over the use of a custody standard in an adoption proceeding. And that's the issue before the court today, as I see it. As Justice Weck has indicated, it's very myopic. Is there standing? Does he stand in loco parente based upon the acquired, his assumption of those duties and his discharge of those duties?
Correct.
Justice Donohue has a
Yes.
question for you.
Counsel, I'm a little bit confused about maybe what your concession is here, and it's on this petition to the standing to intervene versus standing to file a petition for adoption in the first instance. Is it your position that they are two different things?
It's my position that on its face, and I apologize for being redundant, the Adoption Act just says anybody can file. We ended up doing both because there was already an adoption petition filed.
And maybe I'm not making my question clear. If you have standing to file an adoption petition because the adoption statute on its face does not preclude anyone from filing an adoption petition, and you have filed an adoption petition, why doesn't that automatically give you standing to intervene? You have an existing right that you're trying to exercise, or an outstanding procedure that you're trying to take advantage of in adoption, and you want to intervene in another adoption proceeding because if you do not, your right to proceed on your own petition is going to be interfered with.
Yes.
Why do we look at in loco parentis or anything else?
Well, I would argue that, or I would agree that the appellant had a right to file, and therefore that by itself should have taken him to the next level, which is a hearing on the merits.
Well,
So
I'm saying it takes him to the next level in this situation,
Yes.
which is he gets to intervene.
Yes. I'm in agreement. I'm saying yes.
Okay,
I'm in absolutely agreement with that assertion.
But you see, in that context, this whole issue of in loco parentis, which we have never blessed, that whole issue is not part of this equation.
Yes.
Well, I think it has relevance for the reasons that Justice Doherty had indicated, that because under the rule of civil procedure dealing with intervention, you need to have a legally enforceable interest, something that you're trying to vindicate. You can't be, what'd you say?
Legal stranger.
Legal stranger to the case. And in loco parentis is a way to not be a legal stranger to the case, such that you can
It's a
intervene.
filter.
But there could be other ways to not be a legal stranger as well.
Correct.
And maybe one of them is you also have a pending petition for adoption.
Correct.
Except that it becomes circular at some point because under such a rationale, any legal stranger could then get standing by virtue of simply throwing in a petition over the transom. So ultimately, the court's going to have to make that standing determination whether the person is in loco parentis. And so again, I come back to the legal issue, it seems to me, is whether or not this trial judge was correct to say you have to have current in loco parentis status, something that seems impossible when there's been a dependency in TPRs.
Correct.
And I think we got the position. Anything you want to add in conclusion?
No, Your Honors.
No, appreciate it.
I think you agreed with all of us at one point.
Absolutely.
May I ask Attorney Charles S.R., is this your first time arguing before the court?
It is.
Well, you did a very nice job.
Thank
Is
you.
it your last time?
I hope
Not at all. Not at all.
Thank you, Your Honors.
We weren't so bad, were
Not
we?
at all. Not at all.
Thank you.
Ms. Kim, go right ahead.
Good afternoon. May it please the court. Kathleen Kim, counsel for the City of Philadelphia Department of Human Services. I will be sharing my time with the guardian ad litem, Judy Springer. For this argument, I will be addressing standing and in loco parentis issues, while my colleague will focus on issues related to the best interest of the child. I would like to begin kind of with the framework of the law, as that seems to be a lot of the questions that Ms. Charles Assar received. I did want to point out that while the Adoption Act, which governs adoption proceedings, Section 2312 states any individual may become an adoptive parent, as Justice Weck pointed out. We have several other sections that I'd like to point to. For example, 2531A and 2531C are sections that the legislature implemented, stating that a current caregiver or certain family members, such as a grandparent, aunt, uncle, step-parent, can file to adopt. This is important because when we have a dependent child like we do in this case, you need both under 2711A1, the adoptee must consent if they are 12 or over, and under 2711A5, the guardian or whoever has custody, which in this case would be DHS, must also consent to the adoption. Now,
What does consent have to do with standing?
So I believe it comes in through common law. So when Justice Donahue was asking where does in loco parentis come in, we have Superior Court case law that states you either need to have consent or some sort of relationship with the child, and that's where in loco parentis came in.
Well,
so you must show that you currently stand in loco parentis.
Counsel, can I follow up on that?
Yes.
How about if the Superior Court said, because we haven't said anything, but how about if the Superior Court would have said, you know what you need? You need a bond. You know the kind of bond that we look for in termination of parental rights cases? I mean, if you're going to make something up that's not in the statute, wouldn't that be another way of establishing this predicate to being able to adopt? I'm just probing for this idea of I mean, we're talking about this in loco parentis requirement as though it's black letter law, which it is not. And you know, it is embedded in this case, and you know, maybe we have to talk about it that way, but we're in agreement that that is not in the statute, correct?
Yes, it's in common law, in loco parentis. Well, in the statute delineates the requirements for adoption.
It's in the custody statute, but not the adoption.
Correct. Correct.
So you may have opened my eyes in a way here. Are you suggesting that we don't look at the opening section of the Adoption Act to look for a standing requirement? We look to subsequent sections which actually set forth what you really have to have in order to become an adopting parent?
Correct, Your Honor.
So you would not agree then that anyone has standing to file an adoption petition?
And in furtherance of that, I think you were referring to the automatic standing provisions, the statute that you were referring to, with grandparents and siblings, step-parents.
Yes, yes.
Those were the
Well,
automatic
would you answer my question? Would you then disagree with the statement that not everyone has standing to file an adoption petition under the statute?
I believe I would disagree with that statement.
Well, the point is, the statute is that any person may become an adopting parent. The court still has the obligation to determine standing when it's not obvious. Okay, so the reference to parent that you made a moment ago is then question begging because it comes to appellant's position. I'm a parent. So court, you must determine whether I'm a parent by virtue of being in loco parentis, which means in the position of being a parent. And then the legal question is, you know, whether that is foreclosed to people who are not currently in loco parentis, because everything else is for the judge to determine on the merits, right?
Well, in this case, I believe in this case, TB had filed a motion to intervene stating that they had standing, that he had standing as in loco parentis, and what the trial court did, was look at the totality of the circumstances to determine whether TB actually stood in loco parentis. In this case, the trial court found that he did not, and therefore he did not have standing. And in determining whether he stood in loco parentis, he had to look not only at the post-separation contact, which was mentioned earlier, but also at the pre-separation contact, which is what TB believes the trial court did not consider the first 5 years. But the record reflects that the trial court heard all that information, considered it all, but the fact that 6 years had passed and this child had no, that TB had not taken on parental status or discharged parental duties.
Counsel, let's probe that. First question I have for you. Would you agree that more than one person can carry an in loco parentis status in an adoption proceeding?
I believe that could be possible, yes.
Okay. In an agency case for which is your realm, DHS is the parent standing in loco parentis, if not the guardian pursuant to dependent court order.
Yes, DHS stands in loco parentis.
Now, your position is that you are against TB from having the ability, a legally enforceable interest to intervene based upon his alleged abandonment of his ILP status.
Yes.
Yet, in that theory, the basis or part of that estrangement was at the behest of your client. Was it not by getting a protective order and failing to notify this person as to any of the proceedings that were going on as a result, the dependency proceeding, as a result of he not being part and parcel?
Well,
is that fair? Did you guys have a, did your client get a stay away from TB with the child?
I believe to answer that question, I would have to go off the record. Or?
Well, you wouldn't have to go off the record. It's in the briefs. It's in the briefs that there was a stay away. Stay away at the request of the unfounded allegation of abuse against TB and his mother. And then it's further indicated that he had no knowledge of the proceedings because he's not a named party. And you guys are not recognizing him or informing him because you have a stay away. But you want to use that information as justification for giving him a legally enforceable interest to at least intervene and have a say, because fundamentally, you must agree that all evidence pursuant to our jurisprudence is required for an individual judge to make a best interest analysis and determination. Yes?
Yes.
And would you not agree that hearing from an individual that spent 5 years raising the child's life and it's still distorted as to continued contact is information the court should have? Or you disagree the court should be provided with all individuals who have shown affection or, let's say, who have assumed parental duties and discharged them?
Yes, I believe that the court should have all that information. In this particular case, however, TB...
Is it your denial that he assumed and discharged parental duties from the early part of this child's life?
It would be our position that he never stood in loco parentis.
Okay.
I'm confused then. I thought from birth till about age 5, the child lived with him and the birth mother and maybe others.
No, so when the child was born, she immediately went with TB's mother.
They were both incarcerated, the facts. Right?
Yes.
Oh,
yes.
that's right. At first they were incarcerated.
Correct.
Then he gets out and moves in with mom and raises...
Moves in with his mother and the child. His mother is given...
4 days later.
4 days later. The mother was given guardianship.
And his activities, he lived in the home, he took the child to and from school, went to kindergarten, did everything that a father would do.
Right?
Correct.
Yes.
But, so it's the city's position is when an individual gets involved in a child's life and lives with that family and takes that child, assumes the duties of a parent by doing parent-type things, and discharges those responsibilities, that it's your position that they don't stand in ILP.
It's our position that that's part of the inquiry, but there are other things that need to be considered.
Such as?
Within loco parentis, we're looking at two main questions, the assumption of parental status as well as a discharge of parental duties. So when we're looking at the first part, the assumption of parental status, we're looking at what the biological parent was the biological parent intending to share that parental status. And here, even by TB's own testimony, he and the biological mother were not in a relationship. They did not live together.
She was in jail.
Yes, she was in jail.
Be candid with the court. She's in jail. She can't live with them.
Sure.
We can't say that she wasn't going to live with him if she were not in jail. But she allowed his mother to be guardian, and she knew that her paramour, boyfriend, girlfriend, whatever you want to call it, from its transition, her transition into TB, that is a relationship. And TB, he assumed the parental responsibilities for 5 years. Share with us how we don't assume that has established an assumption and a discharge of parental responsibilities such under the intervention statute that is a legally enforceable interest. Just answer that question to put my mind at ease.
Yes, Justice Dougherty. I believe that a judge could find that that would be an assumption of parental status and a discharge of parental duties, but in this case, the trial court found that it wasn't. I also want to point to the fact that even though TB was not present at the birth. He was also not listed on the birth certificate, which would have been another indication.
We know about that, and again, your response to Justice Dougherty fails to mention the apparent legal misapprehension by the trial judge, which I think is why the case is germane at our level, which is that he was laboring under the misapprehension that current ILP status was required. You see, because from that all other errors flow. So why shouldn't this case need to go back in order for this trial court to make a determination, to hear all the evidence that you're talking about now, but without the legal misapprehension that at that particular window in time, he had to be standing in loco parentis, which was a legal impossibility since there had been a dependency in 2 TPRs, and the agency was in the captain's seat.
Well, I believe the purpose of in loco parentis is to recognize whether that parent-child relationship exists, and in this case, TB had the burden to show that he had that relationship, and in
Ms.
this
Kim,
case,
let me ask you a hypo. I'm sort of famous for that might help. Assume hypothetically that for the first 5 years, what's his name? TB, thank you. TB was in loco parentis, which is where I think people are leaning here. And for the next 6 years, had no relationship whatsoever with the child. At the conclusion of that 6 years, TB seeks in loco parentis status. Does he have it by virtue of being in loco parentis for those first 5 years? Or does he lose it over the next 6 years?
our position would be that he lost it. He lost it by his actions and inaction. He's trying to get the rights of a parent without doing any of the parental obligations and duties. For example, with a dependent child in care who's been in care for now 7 years at this point, but he did not intervene until 5 years. She'd been in care for 5 years. But one of the parental duties that you have for a dependent child in care is to try and get that child back into your care so she doesn't have to sit in foster care.
So in loco parentis need not be continuous. But at the moment that someone seeks to intervene in the adoption, they have to be in loco parentis, regardless of what facts makes them in loco parentis. Is that correct?
That would be our position, yes.
But
they
how
have to
could
have
that
some
be-
sort of...
How could that possibly be the case?
In an agency case in particular.
Right. Everybody was displaced by the agency and by the court's decrees.
Right.
So it's a legal impossibility. It's also inconsistent with our decision in TB, where a same-sex partner had standing despite not having been ILP.
Yes, I believe in for example, the guardian. The guardian, if she had continued having visits with the child, she could show that she was trying to get the child back into her care. I believe that that would be a situation where even though the agency has custody, she's showing that she is still executing her parental duties and she still maintains that ILP status.
So you can, even when you don't have custody, even when the child is in guardianship, you can still have an ILP parent?
I'm sorry, could you repeat your question, Your Honor?
Even when custody has been taken away and orders have been issued preventing parental contact, there's still in your mind some factual way for a parent to preserve ILP status.
Yes, just like before we terminate parental rights, the parents, it is their affirmative duty to continue to be the parent for the child, and so in this case,
Counsel,
yes.
you have an agency child, which means DHS was founded to be the guardian through a dependency proceeding. Parental rights are terminated. We've now accelerated to an adoption proceeding for which it's an agency adoption. Share with me. If TB had contacted DHS, would they have been permitted the information regarding the child, his placement, and the fact that an adoption petition had been filed since he is neither, in your mind, or DHS's, a party or a person. He's a legal stranger. Would your office have given him that information, that it was going to be held at 1501 Arch Street in front of Judge X at 3 o'clock on a Thursday? The answer is no.
No. Ms. Kim, I have one more hypo for you.
Yes.
Assume child is dependent, found dependent by the juvenile court, placed with, it doesn't matter, with maternal aunt. Child's 1 year old. Maternal aunt marries. Maternal aunt's new husband moves into the home, lives with the child, carries out what seems to be de facto parental duties for the next 10 years, notwithstanding the child remains dependent, in my hypo, and the agency's the legal custodian of the child. Now maternal aunt wants to adopt that child, and her husband wants to adopt that child. Does he have in loco parentis status, notwithstanding it's a dependent child in the agency?
I think he definitely has an argument for in loco parentis status, yes.
Because the legalities of the status matter less. For in loco parentis, it's a question of whether he's acted as a parent. Is that the way you see it?
Yes, Your Honor.
All right.
Can I just ask two very straightforward questions? Is it your position that only persons in loco parentis may adopt?
No, Your Honor.
Is it your position that only persons in loco parentis may intervene in an adoption proceeding under Pennsylvania Rules Civil Procedure 2327?
No, Your Honor.
So local in your view, in loco parentis status is not required to intervene in an adoption proceeding?
No. In this case, however, I believe TB had conceded that because DHS did not consent, in loco parentis was the avenue for them to.
Okay, so your simple answer to this case would be TB is only pursuing in loco parentis status, and we shouldn't get to the question of who else may be permitted to intervene and whether TB could have intervened under those alternative theories.
I'm sorry, could you repeat the question again, Your Honor?
I'll try.
Sure.
I guess I'm trying to understand. The only issue here, as you see it, is in loco parentis status because that's the way the case was presented.
Yes, Your Honor.
And you're not suggesting that we should go further and look beyond what other class of individuals might have been able to satisfy standing under other theories to intervene in an adoption proceeding.
I believe, yes, that would be our position. I believe this case is, I'm not sure the appropriate, I believe in this particular case, TB was seeking to intervene, have standing through in loco parentis, and I feel that under the totality of the circumstances analysis, TB was found, our position would be properly found under current jurisprudence to not be in loco parentis and therefore to not have standing.
Thank you very much.
Nice job. Thank you.
Thank you, Your Honors.
Ms. Springer, I'm not so sure best interests are before us, but you came, so we'll give you the opportunity to take the photo.
May it please the Court. Good afternoon, Chief Justice and Justices. My name is Judy McIntyre Springer. I am the volunteer child advocate for K.N.L. through the Support Center for Child Advocates. I was appointed as the child advocate in March 2015 when the child was removed from the home and placed into care. With your Honor's permission, I would like to perhaps address some of your concerns and talk about more than best interest, but if I'm only limited to best interest, then I will. But I wanted to perhaps talk about the in loco parentis and because I believe I have a little bit different take than the city does.
Okay, we're looking at standing.
Yes.
But if you want to address loco parentis as it pertains to standing, that
absolutely.
Would be fine.
And on the one hand, we have the rule that we don't repeat arguments. On the other hand, we seem to be a little bit in a mess here, so if you can succinctly straighten it out, go ahead.
Yes, Your Honor. So I don't believe that the standard for someone to intervene in an adoption or for someone to file a petition to adopt is the same. In order for someone to intervene in an action, we can look to the Rules of Civil Procedure, which states that any person who has a legally enforceable interest in the case can intervene in an action, or someone who could have joined in the original action. And through my brief, that is kind of the analysis that I take. So in this case, just because a person is interested in a child does not necessarily make them an interested person. And I know that there is a concern for liberally allowing people to intervene in adoption actions, because certainly the court is interested in really drilling down to what is in the best interests of a child and why should we limit who could come in and testify to that. And the reason why we should limit it in this case, Your Honors, is because this litigant was already determined to not be credible by the trial court judge. And Your Honors can look at the transcript and see on its face that I know we've talked about this person being in a relationship with mom, but don't disregard the line in the transcript. The person, TB testified that TB was in a relationship and that TB was engaged to biological mom. In the very next question, on direct examination, not even on cross, TB testified, well, we weren't really in a relationship. We had been friends since we were children. So take a look at that. No court has ever found TB to have standing. This child was removed from the home where TB was living as an adult with his mother. Just because someone is living in a home does not necessarily make them have in loco parentis.
Wait a minute. Mother was incarcerated. Mother was incarcerated.
Mother was incarcerated, yes.
So when you say living at home with the mother, but the mother was incarcerated.
Living at home with his mother. So TB lived with his mother.
So an individual who has assumed and discharged parental responsibilities for 5 years, in your mind, it does not stand in loco parente?
Your Honor.
That's a yes or no question.
Not in this case, Your Honor. The reason why is because this person never conducted himself as if he were in loco parentis. And the reason why I can stand here today and say that is because TB never stepped foot in the courtroom in the dependency case.
There was a stay away. Would you concede to that?
The stay away order was not entered originally, Your Honor.
Was there a stay away?
There was a stay away.
Was TB noticed by the department that there was a dependency proceeding?
Your Honor, he was at court every appearance. He was in the waiting room.
Okay. So does that not conflict your comment that he was not participating because he was there, he was just not invited in by the court officer?
Your Honor, TB was ordered to stay away from the child. TB was never ordered to stay away from the court. TB was never prohibited from intervening in the dependency.
And who requested that stay away order?
I requested the stay away order. That was part of the January 2021 hearing.
And now you want to use your request for a stay away order as against TB by saying he abandoned his parental responsibilities.
No, Your Honor, I don't have to use that stay away order to demonstrate why TB does not have standing and is not in loco parentis.
But you seem to be doing that by arguing merits issues. So, again, whatever else the trial judge did, and there's a lot else the trial judge did that we did not grant review of that could be seen, as the Chief Justice said, as problematic. But one thing we know the trial judge did was said, I'm repeating this for the third time, the currency point, which, current versus past. So if that's legally erroneous, why doesn't this have to go back? And then you can fight about all these merits issues and say TB was inattentive and TB abandoned without the legal error of saying there's a barrier to that he can't get a seat at the table to fight about it because he's not currently in loco parentis. How is that not reversible error that requires this to be sent back for you to fight about these merits issues?
Sure. So There are no Supreme Court cases, as Your Honors know, dealing with in loco parentis in an adoption action, but there is a line of cases. In re interest of NS, for example, is what states that if a person, because in order to file an adoption action, and the reason why that's relevant for the intervention is because in order to intervene, you have to be able to be joined in the underlying action as a party. So
Well, that's one of the ways to get intervention.
Or have a legally enforceable interest, right?
Or with the legally enforceable interest, or certainly with DHS consent, or with the child's consent. And at the time of the hearing, the child was under 12, and so there was no information on the record. The child now is 12 and now will be in the position where the child's consent cannot be dispensed of. But I haven't answered your question. So on the... it comes from in re interest of NS that talks about currently in loco parentis. And certainly this person did nothing for over 4.5 years to participate in litigation or participate in this child's life. They did not intervene in the 2013 custody action that gave his mother custody. The 2013 custody action, the mother of TB is who was given sole legal custody and sole physical custody of the child. The child was born in 2010, was placed in 2010. 3 years later, it's not TB that the mom is giving custody to. And for in loco parentis, we know you can't just waltz in and take it. There has to be some discharge of parental duties in favor of the person.
Ms. Springer, you're deep into the facts, which is not what we're especially interested in. Now, I understand the nature of the case leads you to the facts, but we're more interested in the law. So again, the same hypo that I asked Ms. Kim. Assume, and I know you don't concede, that TB was in loco parentis for the first 5 years, and then was a complete stranger to the child the next 6 years. Would he be in loco parentis at the time he filed his petition by virtue of his first 5-year status?
No, we terminate parental rights, biological parental rights, on less of an absence.
What do we do, 6 months? Yeah. All right. So your position then is that you can lose in loco parentis if you, and again, that ignores the complexities of this case, as Justice Dougherty has pointed out to you. But hypothetically, you can lose it. You know, and again, maybe it's analogous to an incarcerated individual who has an obligation in a termination proceeding to use all reasonable efforts. I don't know. I mean,
counsel,
you can grab lots of analogies.
Let me follow up on that last comment.
Yes, Your Honor.
You could lose parental rights
Yes,
with
Your
less time. But there has to be an introduction of evidence and a decision on those merits as to whether there was a complete interruption, yes?
That is correct, Your
But
Honor.
in this particular case, you're precluding any decision on the merits by your choice of abandonment for which is not founded in any statute, code, or law in Pennsylvania's Adoption Act, correct? Or can you share with me that your position to our Chief Justice was that abandonment is a cessation to ILP status? Where do you come up with? Can you direct me to which statute, code, or case law you had made that determination?
So, Your Honor, the concept of in loco parentis means that a person is standing like a parent and acting like a parent. And I stand here representing the child's best interests, and what I look to is how TB behaved. And I'm not talking about underlying merits. I'm talking about procedurally from a litigation standpoint. A person who perceived themselves to be in loco parentis and was acting and carrying out the duties of a parent would have been beating down the courthouse door.
So my question to you, which you have not answered,
I'm sorry,
is
Your
there
Honor.
a case law, is there a statute or some code or rule that defines abandonment or even acknowledges abandonment of ILP status? That's a yes or no answer.
Not that I'm aware of, Your Honor.
Okay.
I did have one other question.
You've been asked on several occasions, or you started to describe for the court why the record in this case does not support the ILP status of TB, and each time you were interrupted. So I just want to hear the rest of your answer to that. And I think you left off at the time that you requested the stay-away order.
I appreciate the follow-up question. The child was placed in 2010. I know we're not focusing on the facts. TB did not file for custody. 2013, custody order was entered, not naming TB. TB didn't file to intervene, didn't do anything to participate in that action. In 2015, when the child was removed, again, did not participate in the action, didn't ask for visitation, didn't testify as a witness, did nothing. 2017, parental rights were terminated. 2018, a petition to adopt was filed. And again, TB did nothing, did not participate, did not file to intervene. In 2019, June 2019, maternal aunt filed a petition to adopt. For 6 more months, TB did nothing. And it wasn't until December 2019, over 4.5 years after the child was removed, that TB came into court and said, look, I'm in loco parentis. We terminated rights not only of the biological mother, but also the putative father. And also, we had to apply about the same standard, and we went up to the Superior Court twice to vacate TB's mother as the legal guardian. Had TB come in and announced himself as having any right to the child at that time, we would have had to have gone through the court process to deal with it.
During that history, at what point was the stay-away order requested by you and granted by the judge vacated?
How long did it last, the PFA?
So there was no PFA. There are no
There's a
grounds for
stay-away order.
PFA. There was a stay-away order. So there were multiple stay-away orders in the dependency action. In the January 2021 hearing, I asked for a stay-away order. I tried to ask for that stay-away order, as the transcript shows, before TB was dismissed. This was not anything that I wanted to do or chose to do behind TB's back. I tried to take care of business before TB and his counsel were dismissed. The record's clear, the judge would not permit me to do that. The reason why I asked for the stay-away order is because TB had been he'd been appearing at the school and the daycares and trying to get access to my child and to my client, and I was concerned, and that's why I asked for the stay-away. Yes, Your Honor.
Are you standing in capacity as K.N.L and child advocate?
So fortunately, Your Honor, this case, I am permitted to do that because, and case law shows I'm permitted to do it, the child's wishes and the child's best interest are in alignment in this case. Certainly, if they ever were to diverge, I would not be able to serve in both roles, but they are in alignment.
Was that
Your
a
Honor.
finding by the court, or is that your position?
I believe that there's significant, which part, Your Honor? The part where
The alignment.
the fact that they're in alignment is because I have
Did a court make a finding? Did a court make a finding of that?
No.
So that's your argument position.
No, but what my client wants is consistent with what I'm arguing today.
All right. That's not in the record, just for purposes of
It's
argument.
not. I'm sorry. I was just trying to answer a question.
I have one more follow-up.
Sure.
Is the waiver of ILP, is that a legal determination or is that a factual determination?
Of whether someone is in loco parentis?
If somebody's waived their right
Someone's
to be
waived.
in loco parentis.
I would say that would be, I don't know that there's any discussion of a waiver of ILP in the case law. What I would say is it would be a factual determination of whether someone maybe has lost ILP status or never gained ILP status.
All right. Thank you very much.
Okay, thank you, Your Honors.
Appreciate it. Ryan, call this court to... Before we adjourn, just thank you to the National Park Service. It was wonderful to argue in this courtroom. Thank you all for being so patient.